My name is Katie Byrne. I'm the Acting Executive Director of the BMZA. To my left, we have the board's attorney, Becky Witt. Simon Penning is also helping out today because I may have to leave for a little bit to go down, or to go up, third time I've said it today, to go up to the council chambers. We have Leland Shelton, who is a board member. We have James Fields next to him, who is our chair. We've got Bill Cunningham, who is also a board member, and Sabrina Turner, our board member. We have 4 board members today here for the hearing. Cases will not necessarily be called in the order in which they are will appear, so please listen closely for when your case is called. And I will turn this over to Mr. Fields.
Good afternoon, folks. If you have any cell phones with you, which most of you probably do, just please turn them off or silence them, since we have lots of recording going on here. We will hear your cases and endeavor to reach a ruling or decision on the case at the end of either at the end of the docket or at the end of the matter. Last week we went to a new practice where we're going to seek to deliberate on the contested cases.
Please be quiet.
Immediately after those cases, and then keep the docket moving. You may feel free to stay in the room and listen to the deliberation, but you certainly cannot participate in that portion of the hearing. Otherwise, you can feel free to contact the BMZA office after today, 410-396-4301, to hear the results of your case. We ask that you not take any action towards your project until you get your formal decision, and certainly don't do any work in Baltimore City without pulling the proper permits. Our case is divided up into a couple of sections. We have consent cases, and then we have contested cases. We also have postponements, and I'll get to those in a second. Those consent cases are cases for which the board believes it has sufficient information to approve the appeal. And so what that means practically is that you will all come up. We will call those case names. We will hear reports from our staff and from the planning department, and then we will resolve your case on the consent docket. With regard to those other matters that are contested, petitioner goes first. It will be to my left. The opposition will be on my right. We will hear arguments from the petitioner, then we will hear from the opposition, and then the petitioner has the final word on rebuttal. With regard to oppositions, there may be some contested cases here that have plenty of opposition. Just know that to the extent there is a basis for the opposition that's already been stated by someone else who is testifying, we don't need everyone to come up and repeat the same basis for the opposition. Once we know what that issue is, we're well able to factor that in to the decision and consider that along with all the other factors that we have to consider. And so I would caution you to not be repetitive in that regard so we can keep the docket moving. There are, again, a number of postponements on today's docket. I know that Ms. Byrne talked to some folks with regard to case number 2022-151, 925 Ramsey Street. Adrian Beagle's the appellant. That matter has been postponed. It will not be heard today. Again, that's 925 Ramsey Street. Other postponements that are on this docket, case number 2022-130, 3417 Chestnut Avenue. Topping LLC is the appellant. That matter is postponed. Case number 2022-142, 1501 North Bentlow. Nick Bowes is the appellant. That matter is postponed. 1501 North Bentlow. Case number 2022-145, 1201 North Linwood Avenue. Bashir Ali Al-Haddad is the appellant, and that matter is postponed. 1201 North Linwood Avenue. Case number 2022-160, 1837 Clifton Avenue. (2022-160) 1837 Clifton Avenue. Denitra Bell is the appellant. That matter is postponed. 1837 Clifton Avenue. And finally, 2022-164, 1621 Lancaster Street. Michael Snydall is the appellant. 1621 Lancaster Street is postponed. Okay. Second to the last one. Okay. Thanks.
Take your phone.
One came off consent and went to regular. I'll call that. So I'm now going to call the consent cases. When I call those cases, if you would line up to my left, your right, in the order that I call the case. Start with case number 2022-116, 200 through 202 East Preston Street. Mira Kitchen is the appellant. Case number, right here, ma'am. Right there is good. You'll be first called. And everyone else on the consent docket is going to be to the right of Ms. Kitchen. Case number 2022-140, 3621 East Lombard Street, AB Associates, the appellant. Case number 2022-146, 3208 Bonnie Road, Eliyahu Cohen. Case number 2022-149, 4522 through 4524 Reisterstown Road, Malad Atashi. One up. Case number 2022-150, 2926 St. Paul Street, Andy Niazi Architecture. Case number 2022-153, 1826 Jackson Street, Matt Knopfel. Case number 2022-162, 446 North Linwood Avenue, Backbone Creation, Inc. Okay. And case number 2022-166, 1108 Scott Street, Denise Butts. Those are our consent cases for today. We could have all of those parties sworn in. Swear the party.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Thank you. Calling the first case on the consent docket, case number 2022-116, 200 through 202 East Preston Street, Mira Kitchen. This matter seeks to add outdoor dining and catering to existing restaurant and locate portion known as 1301 North Calvert Street. Is that correct?
Correct.
All right. I'll hear from planning and staff, or staff and planning, whatever order you like.
Martin French for the Baltimore City Planning Department. The Planning Department has no comment on this application, but notes that this property is located within the Mount Vernon Historic District, and any exterior changes to the building in association with this appeal should be covered by an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Thank you, Mr. French.
Issue before the board is adding accessory outdoor dining and catering uses to an existing neighborhood commercial restaurant.
Good? All right. Okay, Ms. Kitchen, is there anything you'd like to add to your application today?
No, there was previously outdoor dining with the previous tenant.
Okay. Well, the board having heard your appeal, we believe we have sufficient information to approve your appeal.
Okay.
Thank you so much.
Thank you.
Case number 2022-140, 3621 East Lombard Street, AB Associates. Mr. Berry, welcome. This matter seeks to use first floor as a neighborhood commercial establishment. Is that correct?
That's correct.
All right. I'll hear from planning and staff.
Planning Department has reviewed this application and has no objection to its approval. Thank you.
Thank you, Mr. French.
It's a neighborhood commercial establishment restaurant. Last authorized use for the property was as a personal services establishment plus one dwelling unit. Prior to that, there was a building and loan association. So we have a history of commercial use.
Okay. Mr. Berry, is there anything you'd like to add to your application today?
Only thing to add is that the unit on the second floor residential is under renovation, near completion, and we look forward to your approval so we can finish the first floor.
Very well. The board, having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you.
Thanks so much. Case number 2022-146, 3208 Bonnie Road. Mr. Eliyahu Cohen.
Hello.
Welcome, sir.
Thank you.
This matter addresses structural alterations, enclosed portion of existing front porch, and relocate the front door to create a foyer, extend existing front porch, concrete slab, and you're seeking to build a third floor addition, 21 feet 6 inches by 26 feet 6 inches. Third floor is over the existing front porch roof. Is that accurate?
It's actually a second floor. It's a split unit. I think that was Miss.
Okay, second floor. All right, I'll hear from planning and staff.
Planning Department has no comment on this application. Thank you.
The only issue really before the board is one variance requested. Minimum front yard setback, 30 feet is required, 28 feet is proposed, so it's a 2-foot variance that's required.
Okay. All right, Mr. Cohen, is there anything you'd like to add to your application today?
That's all, sir.
Very well. The board, having heard your appeal, we believe you have sufficient information to approve your appeal.
Thank you.
Good luck to you. Case number 2022-149, 4522 through 4524 Reisterstown Road. Milad Atashi,
Yes, sir.
welcome. This is a request to use premises as ground floor as a retail clothing store. Is that correct?
Yes, sir.
All right. I'll hear from planning and staff.
Planning Department has reviewed this application, noted that this property is located within the Park Heights Urban Renewal Plan area. And on that basis, the Planning Department recommends that approval of this application be subject to the condition that all exterior changes to the property, including signage, are completed or installed in accordance with plans that would be approved by the Department of Planning. Thank you.
Neighborhood commercial establishment, retail sales. The property is again located in the Park Heights urban renewal area. The URP does not prohibit or restrict this use. It does contain standards by design standards which the applicant should consult. The property has a history of legal commercial use in the first floor. The current UNO is for personal services establishment plus one dwelling unit.
Okay. Mr. Atashi, are those conditions stated by planning acceptable to you?
Yes.
All right. Is there anything you'd like to add to your application today?
Just beauty supplies.
I'm sorry?
Beauty supplies next to clothing. Clothing and beauty supplies.
Okay, retail clothing and beauty supply.
Just for the board's reference, it would be all general retail sales. It would fall under that same definition and category.
Sound good?
Doesn't require any change anywhere else.
Oh, all right.
Okay.
All
Thank you
right.
for that clarification.
Thank you.
The board, having heard your appeal, we believe you have sufficient information to approve your appeal.
Thank you so much. I'm done.
You are.
Y'all have a blessed day.
You too.
Case number 2022-150, 2926 St. Paul Street, Andy Niazi Architecture. Are you Mr. Niazi?
Yes, I am.
Okay, welcome, sir. This is a request to construct a roof deck and pergola on existing detached garage. Is that correct?
That's correct.
All right. I'll hear from planning and staff.
Planning Department has no comment on this application. Thank you.
There's just slight discussion on this for the board's information. So the existing garage is a structure that is at the rear of the property, so it abuts to the side and rear lot lines. What's being built is a structure because a deck and a rooftop and a pergola are defined as structures, but it's not an enclosed structure. So if it were an enclosed structure or a second floor, then the board could not grant this because it would be adding to bulk or mass. This is just a structure, so the nonconformity of the existing building isn't impacted because you're not increasing the bulk, you're only adding the structure. So, that's that little preliminary.
Okay.
In a second, I will give you the specifics. Oh, here it is, okay. So, what the board is being asked to grant are 3 separate variances. Maximum height, 15 feet is allowed, 21 feet 2 inches is proposed, so it's a height variance of 6 feet 2 inches. Rear yard setback, 25 feet is required, 1 foot 4 inches is proposed, so it's a 23 foot 8 inch variance requested. Interior side yard, 10 feet is required, 9 feet is proposed, so it's a 1 foot variance requested for the deck and pergola.
Okay, is that good?
That's it.
All right. Mr. Niazi, is there anything you'd like to add to your application today?
No, sir.
All right. Board, having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you.
Thank you. Case number 2022-153, 1826 Jackson Street. Mr. Notful?
Yes.
How are you, sir?
Good, how are you?
Well, thank you. This matter seeks, this application seeks variance to bulk regulations related to the construction of an addition at the second floor rear. Is that correct?
Correct.
All right. I'll hear from planning and staff.
Planning Department has no comment on this application. Thank you.
The minimum rear yard setback is 20 feet is required, 10 feet is proposed, so it's the full 10-foot variance. Maximum lot coverage, 60% is allowed, 8.75% is proposed, so it's a 27.5% variance required.
Okay. Sir, is there anything you'd like to add to your application today?
No, there's not.
All right. Board, having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you.
And 2022-162, 446 North Linwood Avenue. Backbone Creation, Inc. Okay. And your name, sir?
My name's Steve Annis.
I'm sorry, last name?
Steve Annis, A-N-N-I-S.
Okay. And you're here for Backbone Creation?
That's right.
All right. And this is a request to use the premises as 2 dwelling units, correct?
That's right.
All right. I'll hear from planning and staff.
Planning Department has reviewed this application and recommends approval. Thank you.
Property has historically been used as a commercial on the first floor, plus 1 dwelling unit on the second floor. The applicant is requesting to change the first floor commercial use to residential. So it's not considered a conversion because we have an existing dwelling unit and it's a swapping, basically the existing commercial for 1 dwelling unit. The variances that are required are minimum lot area, 1,500 square feet is required, 1,050 square feet exists, so it's a 450 square foot variance requested. Maximum lot coverage, 80% is allowed, 100% exists, so it's a 20% variance requested. Rear yard setback, 25 feet is required, 0 feet exists, so it's a full 25-foot variance requested. 1 new dwelling unit, 1 parking space is required, 1 space, none are proposed, so it's a 1 space variance requested.
Thank you, Ms. Byrne. Mr. Annis, is there anything you'd like to add to your application today, sir?
No, sir, this is looking to improve the community.
All right, well, we look forward to it. The board, having heard your appeal, we believe you have sufficient information to approve your appeal. Thank you so much.
Thank you, sir.
And final case on our consent docket, case number 2022-166, 1108 Scott Street. Denise Butts,
She's not here today.
you are, sir?
I'm Troy Wilson. I'm the property owner.
Okay, I'm sorry, your last name?
Wilson
Gotcha. And this is a request to use the ground floor as a restaurant carryout.
and the basement storage.
And what?
The basement is storage.
Basement is storage. Okay, I'll hear from planning and staff.
Thank you. Planning Department reviewed this application, notes this property is located in the Washington Village Urban Renewal Plan area. The application requests approval of a restaurant and a carry-out food shop. The department has determined that the restaurant would be approvable, subject to the condition that it applies with all requirements for neighborhood commercial establishments provided in the zoning code and with the design and rehabilitation standards of the Washington Village Urban Renewal Plan. The department recommends disapproval of the portion of the application pertaining to a carry-out food shop because a carry-out food shop is a non-conforming use in the R8 zoning district that contains this property, and the zoning code does not authorize creation of new non-conforming uses. Thank you.
Thank you, Mr. Branch.
Again, conditional use restaurant is approvable by the board, carry-out food shop is not. It doesn't mean that you can't have carry-out food from the restaurant, it just means you cannot function solely as a carry-out food shop, right? So people can sit down, do a to-go order, they can call in, pick up, but the primary use is as a restaurant. see. And that's all I have.
Very good. Mr. Wilson, is there anything you'd like to add to your application today?
No, sir.
All right. Well, the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you.
We'll turn our attention to the regular docket, or the contested cases, and they will follow in the manner that I previously stated. The first matter we're going to call is case number 2017-073, 5715 Roland Avenue. We have Joseph Woolman. Mr. Woolman,
Good afternoon, Mr. Chairman.
welcome, sir. And this matter addresses the remand of BMZ 2017-73 regarding the revocation appeal of permit use 2016-03740 and setback variance per section 4107B2. We have Mr. Woolman. We have opposition that's represented by counsel.
Good afternoon, Michael McCann.
Okay, Mr. McCann. And this matter is limited to some very narrow issues, as indicated by the Court of Special Appeals. I'll tell you what, why don't you go ahead and give the preamble?
Gentlemen know better than anyone else here the history of this case, up, back, up, back. So the last stop was the court, the circuit court, and the judge identified specific questions that she wanted the board to consider, and specifically requested expert testimony. And those questions were: was there practical difficulty in building the landscape infiltration facility on another part of the property? Was there a practical difficulty in moving the garage and breezeway back 10 feet? Those are the two questions that need to be answered. So the expert testimony, everything should be confined to those two specific questions.
And gentlemen, what we'd like to do is, I guess for this oral argument and presentation, is limit you all to 20 minutes in your presentation, with about 10 minutes of cross-examination, to the extent either of you desire to do that. Certainly, Mr. Woolman, you'll proceed, and you'll hear the opposition, and you'll have the last word. But we think if we can confine it to those parameters, we can pretty much get the specific information that we're looking for, okay? All right. Mr. Woolman, floor is yours.
Thank you, Mr. Chair, board members. I'd like to elaborate a little bit on what Ms. Byrne laid out, because I think, as the chairman has correctly stated, the issue here before you is very, very narrow. This case is now before you for the third time. The case number itself highlights the history behind this. This is a dispute at the end of the day over 10 feet of front yard setback by a neighbor who lives a couple doors down on Roland Avenue. So the case did go up to Annapolis back in 2017, and I'll just read a couple of quick excerpts to help outline the issue for the board and for the record, as unfortunately we anticipate further appeals in this matter. Reading from page 19 of the Court of Special Appeals opinion on remand, the board, and this was the first remand back that you already ruled upon. On remand, the board must articulate the particular practical difficulty caused by the property's unique physical characteristics. We recognize, based on the briefs and oral argument, the asserted practical difficulty could be the placement of the landscape infiltration facility. So the Court of Special Appeals framed the issue for us and narrowed it down to that one small issue way back in 2017. Furthermore, on page 20, the court wrote it could be that without a 30-foot setback, the house could not have been built as designed because the landscape infiltration facility could not have been located anywhere other than within the 10 to 12.5-foot gap. The board discussed the location of the infiltration facility, but the issue was absent from its written order. And then finally, on remand, the first time the court sent this back to you, the board was ordered to discuss its findings of fact and the practical difficulty caused by the characteristics of the property that make it unique within the legal framework of the three McLean factors. So nowhere did the Court of Special Appeals require you to take expert testimony. I think it's important to point that out, because I think you guys got it right the first time when we were back here a second time because of the circuit court. But my position, and we argued this at circuit court obviously, was that there was no need to take additional expert testimony. You were merely to identify what this practical difficulty was, and the Court of Special Appeals even suggested, almost hinted at, this landscape infiltration facility. Seems like that would probably be it, but the board didn't include it in its written order. So really what they were asking you to do was to identify that practical difficulty. And I think you did that in your last order, but here we are again. So you did do that in your last order. That order was also appealed to Circuit Court, and that was before Judge Hong. And I'll read a couple of statements from her remand order, which helps frame this issue a little bit further. Again, we didn't necessarily agree with Judge Hong, but this is where we are. She pointed out that the petitioners argued, the petitioners being Mr. McCann and his client, argued that the exact same house and garage constructed by the respondent could be moved back 10 feet on the lot and thereby comply with the required 40-foot setback without any impact whatsoever on the utility easement, the forest conservation easement, without the need for a variance at all. So that was, that's the position of the neighbor a couple doors down. The court wrote that while the board did not specifically identify the 3 McLean factors in its resolution, it did address each factor. So Judge Hong found that you all did your job and addressed those factors. The court also pointed out that the petitioner's brief included a diagram, which we'll introduce again for the record today, but it's already in the record, the long record and the long history of this case. They provided a diagram which they argued demonstrates that the 40-foot setback could be complied with in line with the restrictions on the property. And I'll introduce that at this time. I'm sure Mr. McCann's familiar with it because it's his exhibit, but I have a copy for him. Sure. And I have copies for the board. And I'll just mark this and ask it to be accepted as exhibit number 1. This is a general site plan that shows a couple of green arrows that were drawn on it, indicating where they think the house could be moved back. So I'll introduce that at this time.
Very well.
And again, that's already in the record in his memorandum and previous proceedings. And then what I thought was really interesting in the circuit court's order that has us here today, Judge Hong wrote that while identifying respondents' practical difficulty in complying with the 40-foot setback, it was conclusory. So the court is recognizing that you all did your job based on what the Court of Special Appeals asked, which was to identify the practical difficulty. But for whatever reason, again, we were in disagreement. The court, and perhaps it was abundance of caution given the long history of this case, that there be some expert testimony to further elaborate, if you will, on this practical difficulty. Again, I think the Court of Special Appeals properly identified it, and you in turn properly identified it in your most recent order. But here we are today with a need to provide for you expert testimony. So we have the project architect who's here. I'll briefly introduce him just in case you had questions for the architect. The architect obviously was responsible for the design of the house. He's certainly not responsible for the design of the landscape infiltration facility. That falls upon an engineer, and we have an engineer to testify about that. But Mr. Sokolowski, if you just identify yourself for the board, would be great.
Good afternoon. My name is Ian Sokolowski. My company is Design Evolution Architecture. We're the architect of record for this house.
And Ian, you designed the house, obviously, and I'm assuming, correct me if I'm wrong, that in terms of designing stormwater management on a residential site, that falls to an engineer, not the architect on the project. Is that
That's correct.
Okay. I really have no further questions for the architect. The design of the house is not an issue. I just wanted to please the court because they mentioned that the architect was at the last hearing and you didn't stand up and say anything. So he stood up and he said something. So unless you have any questions for him.
Well, I do.
Sure.
Sir, so did you design well, let me just ask you the question that was contained in the opinion of the Court of Special Appeals. Was there a practical difficulty in moving the garage and breezeway back 10 feet, based on your expertise?
Yes, there was. We knew we needed to reserve some space for a stormwater management system. So when we preliminarily placed the house on the property, we left that specific placement to the civil engineer at that point. So the buildable area of this lot was consumed by the house, the pavement, and then we knew that the stormwater management system would need some area.
But I guess in echoing Mr. Woolman's statement, you don't have any opinion on whether or not the stormwater infiltration system had to be placed where it was.
We had a general understanding that it would have to, just understanding how the contours of the land were moving, and we needed just area, just permeable area on the lot for the stormwater management system to be utilized.
Okay. Well,
So-
beyond knowing that you have a stormwater management system
Yeah.
and there needs to be some space, you're not here to offer any opinions about where that stormwater management system was required to be placed.
No, no.
Okay. If the stormwater management system had been placed in a different location, would it be your contention that the construction of the house would have been roughly the same distance from that stormwater management system, depending on where it was?
I'm sorry, I'm not sure, because I really can't speak to how the stormwater management system is broken into several components. So I really can't speak to how large they needed to be and so forth. That was based on a lot of calculations that I wasn't really involved with. So all I can really talk about is just basically the footprint of the house.
And with regard to where the stormwater management system or infiltration system was in fact placed, is it your testimony that the house that you designed could not be built anywhere else on that property?
That's correct.
And the reason for that is what?
The stormwater management system needed to take up some space. We knew that there was a large portion of this that had to occur at the rear of the property. So.
Any further questions from the board?
No. Just a couple, oh, I'm sorry.
I said I have no questions.
Just a couple of follow-up questions, and thank you, Mr. Chairman. And I think you'll get more detail from our expert on from the engineering standpoint. But in terms of the building envelope, which you look at, you're hired to design a house. You look at the lot. You look at the building envelope. My understanding is there were restrictions on this lot as far as conservation easement and utility easement that further restricted where you could not only put the house but put the stormwater management facility. Is that correct?
That's correct.
I have nothing further at this time.
Okay. And in follow-up to Mr. Woolman's question, those conservation easement and, utility management easements, given those easements, based on your expertise, was there any ability to, again, move the house further back?
No. No. In particular, the stormwater, or the forest conservation easement.
And why is
was
that?
a hard stop.
What about the forest conservation easement?
We cannot build into to that easement at all. We cannot disturb the area within that boundary.
And to, I gather from your testimony then, to place the house anywhere else would have in fact encroached upon those easements?
That's correct.
Okay. In light of that, any further questions from the board? All right.
Nothing further.
Okay, thank you.
Mr.
Oh, absolutely.
I didn't know if you wanted me to wait to the end.
No, I think if it's okay, I think it'll run
I don't want to
more
cut
smoothly.
Mr. Woolman's time.
No, if you can go ahead and cross-examine, I think there might be some of that for both witnesses.
Great. I think Mr. Fields, you covered a lot of my questions, actually. So, good afternoon, sir.
Good afternoon.
As you just indicated, you designed the site plan, correct? You prepared the site plan for the project?
Not with regard to the civil engineering.
Could you speak into the mic?
Sure, yeah. You are not an engineer.
No, I'm not.
You're not a stormwater management expert in any way?
I'm not.
You don't prepare, file, and seal stormwater management plans with Baltimore City?
No.
Okay. You mentioned the forest conservation area. That is in the rear of the property, correct?
That's right.
In fact, I have a binder of exhibits, but let me just show you. actually a copy of Mr. Woolman's Exhibit 1, just a blown-up version of that very same exhibit. Am I correct? I know it's very difficult to see, but the forest conservation easement is this area, I guess, in this depiction, to the east of these green arrows that I have here, correct?
That's correct.
Back here. So between the house, which I have highlighted in yellow, and the beginning of the forest conservation area is more than 10 feet, correct?
I'm not sure exactly. Is there a dimension on there?
Well, there are a lot of dimensions on these plans. You don't know one way or the other, looking at this plan, whether or not there's more than 10 feet.
I can't say one way or another what's on there
Well,
without measuring it.
So in follow-up to Mr. Fields' question, if there was more than 10 feet between the rear of the house, that is the most eastern portion of, I'm sorry, the garage, not the house, and the beginning of the forest conservation easement, you would, in fact, in response to Mr. Fields' questions, you'd be able to move the house, the breezeway, and the garage back 10 feet.
Not necessarily.
Why is that?
The stormwater management system consumes part of that.
So it all comes down to stormwater management, does it not?
It does.
Okay, but you're not an expert in that area?
I am not.
Okay. Now, in terms of the size of the house itself, I have calculated, according to some floor plans, which we will introduce, is approximately 6,000 square feet if you consider all 4 floors. Does that sound about right?
Perhaps.
Okay, and then the garage, which I wasn't including in that figure, is 900 square feet, correct? Does that sound about right?
Perhaps, yeah.
Okay, and then there's also an attic, a sort of a second floor to the garage as well?
If I recall, yes.
Okay. What are the parking space requirements in this zone? Do you know offhand?
One parking space per dwelling unit.
So for this house, there's 1 parking space required?
Yes.
Okay, so there's no requirement in Baltimore City that you have 3 parking spaces?
No,
Or a 3-car garage?
not that I'm aware of.
Okay. Let's make sure I have nothing else. Okay, great. Thank you, sir. Thank you, Mr. Fields.
Thank you.
Nothing
Mr.
further.
Woolman?
Nothing further.
Okay.
Next, I'll call Rick Richardson, who is our engineering expert. Mr. Richardson, could you introduce yourself to the board, please?
Yeah, my name is Patrick Richardson of Richardson Engineering, licensed engineer in the state of Maryland.
And I know the rules of evidence don't apply here. I won't go through a detailed litany and qualifications. I do have a copy of Mr. Richardson's resume with his background. I can have him briefly tell you how long he's practiced both here in the city and the surrounding area. If Mr. McCann wishes to ask any questions of Mr. Richardson, he can certainly do so regarding his experience. But Rick, if you could briefly describe to the board your certifications, whether you've testified here in engineering matters in the past, whether you've been accepted as experts in jurisdictions in the area, and specifically whether you're responsible for stormwater management design in residential development projects like this.
Yeah, so I graduated in 1982 with a bachelor's in civil engineering and got registered in the state of Maryland in 1988. I've had my own company since 1999. We do almost exclusively land development work in mostly Baltimore County, Baltimore City, and a couple of the other jurisdictions around. I've been before this board many times. I've been accepted in Baltimore County numerous times at both the administrative law judge and Board of Appeals. I've been qualified in Howard County and in Anne Arundel County. And we do all facets of land development work for clients building new houses, subdivisions, commercial projects.
And Mr. Richards, that experience includes the design of stormwater management for residential sites, correct?
Yes.
And my understanding is you were not the project engineer on this particular site. That engineer has since moved and is out of the market now, but you're familiar with this project, is that correct?
Yes, I reviewed the project.
And you've had an opportunity to review the site plan, which is much more detailed than the first exhibit that we introduced, and we've actually blown it up, so hopefully the board can see that a little bit. And then I'll just for the record, I'll introduce a paper copy for the file.
Okay, wonderful.
As well as exhibit number 2. So I think the easiest way for this to work, Rick, is for you to describe to the board, or I'll lead you through part of it just to try to get to the point. This landscape infiltration facility, which I knew nothing about before I got it, I now know more than I ever want to know about landscape infiltration facilities. But that's this hatched area here. Is that
Correct.
Is that correct? And that's to the rear of the site, correct?
Yes.
And it's right up against the boundary of the forest conservation easement, correct?
Yes.
And do you agree with Mr. Sokolowski that you're not permitted to disturb anything within the forest conservation easement? Is that correct?
No, you can't.
And then is it also correct that the landscape infiltration facility also comes right up against the driveway that enters the garage?
Yes.
Okay. So there's no more room between the driveway, the garage, and the forest conservation easement than that is taken up by the landscape infiltration facility, correct? There's no
Correct.
more-
Right.
It's almost squeezed in there, if you will.
Yeah.
So, okay. So what I'd like you to explain to the board is why, because that's the question from the circuit court, why did it have to go here? In other words, I think really what we're here about today is the placement. I mean, it's really the only issue before us is the placement of this landscape infiltration facility. Why did it need to go here? If you could explain that to the board.
So if you look at the property, he's got 2 different points of interest, this POI here and POI here. And when you're doing stormwater management, you're basically trying to analyze where the water is running off to where it leaves the site. And so he has chosen the back of the site and the front of the site because the site is pretty much running from a south to north direction.
Can you, when you say he has chosen, which he do you mean?
Mr. Sokolas,
The architect or the previous engineer?
the previous engineer.
Okay.
So in evaluating that, he's got to get the water to run to a place where it's not going to be harming the downstream. And he also has to make sure he manages the water so it's not increasing the water downstream. And if you look at where this is, where the adjoining house is, the water is basically going around the house now, and he just needs to keep it going around the house. And so he's got 2 different points. And he's analyzed both of those points. And in order to satisfy the regulations, MDE regulations, he has come up with two basic facilities and a couple of other measures. But he has the infiltration facility here in the rear to take the back side of the property, and he has a dry well up here, which is an underground stone pit, basically, to handle the front side of the house.
And Mr. Richardson, again, just to elaborate on the question, you refer to he, referring to the project engineer, because just to be clear, this is not a plan that you drew. This was actually the plan that was drawn at the time, years ago, for the project, and this is the plan you're reviewing, correct?
That's correct.
And based on your expertise, put it this way: if you were approaching this project yourself, and based on your expertise, where would you have put this landscape infiltration facility in the same place?
Yes.
And why is that?
Once again, you've got 2 different paths that the water is leaving. You need to treat both parts. The only place to put something over here is here, right alongside of the forest buffer and between there and the driveway. It's the only place it can go.
And to answer the question posed or the point raised by Mr. McCann that he put in his brief before the courts, could the exact same house be moved back 10 feet, giving a 40-foot front yard setback instead of 30 feet, without disturbing what's required to engineer the site?
Well, so this infiltration system here is just barely large enough for what the design was required. You have to be able to drive in and out of the garage, so if you push the garage back behind here, you've lost the use of part of the garage. So in my opinion, this is the only place for this house to go on the property, given the constraints of the forest conservation, the stormwater management, And also, you know, he couldn't go up here into the 15-foot easement up there. So there's no place else to put the house other than right there.
Thank you. I have nothing further at this time.
So when you say there's no place else to put the house, could the house have been situated differently as built? And then allow the infiltration system to be placed somewhere else? For example, if it was turned around, turned sideways maybe, is that a possibility?
No, this wouldn't meet the setbacks
Okay.
going side to side.
Okay, so there would have been no way to configure or rotate the house to fit on the property.
Not in my estimation. You need enough room to get in and out of the garage, so the garage has to be facing towards this way, and the house needs to go here, and the garage needs to go behind the house. So I don't see any other alternative.
Okay, that's all the questions I have. Mr. McCann?
Yeah, thank
Would
you,
you like
Mr.
to
Fields.
examine the witness?
Mr. Woolman, would there be another witness, or otherwise I'll save some questions, or is this your witness?
No, that's our case in chief, yes.
All right, thank you. Good afternoon, Mr. Richardson.
Good afternoon.
We meet again. As you indicated, you did not prepare this stormwater management plan, which is the applicant's Exhibit 2, correct?
That's correct.
Okay, do you know who did?
Civil Unlimited, Steve Shimoniak.
You know why Steve Shimoniak is not here today?
Because I've picked up several projects that Mr. Shimoniak has abandoned. I don't know what's happened. He's kind of gone incommunicado.
Okay. You mentioned, you talked a great deal about the infiltration facility that's on this plan. This was the plan, I agree with Mr. Woolman, that was presented to the board when we were here before. Would you agree with me, under the Maryland Stormwater Management Design Manual, there are a multitude, I think as many as 35, what are called stormwater management practices, 34 other than an infiltration facility. Would you agree with that?
I don't think there's quite that many, but there are a number, yes.
Yeah. And then of those 35, at least around 15 of which are called environmental site design facilities. Do you agree with that, roughly? And environmental site design, for the board's reference, and I don't think Mr. Woolman would disagree with this, is a newer type of stormwater management practice, where the idea is to conduct management on site in smaller facilities that take in and do so in a more natural way. Is that a fair way of putting it?
Yeah, that's the attempt, yes.
Yes, and ESD is the new state-of-the-art sort of.
Yes.
So aside from infiltration, there are at least roughly a dozen or so more other practices in the design manual.
Yes.
And Baltimore City has adopted the design manual as the standard for stormwater management in the city, correct?
Yes.
Okay. Have you been to the site?
Yeah.
Okay. Would you agree with me that this plan that we're looking at, which is the applicant's Exhibit 2, is in fact not what exists on the site today, that there is no infiltration facility on the ground at this property? In fact, I'll show you, this is a photograph which will be one of our exhibits. Do you see the house there's an aerial photograph. Do you see the pavement?
For the record, I'm going to object to any questioning about current conditions on the property. This is a review of a plan that was approved by the city and the board back in 2017. So just, again, for the record, I understand the rules of evidence don't apply, but I'd like to object for the record. This goes beyond the scope of what you're reviewing at this time.
Understood. You continue.
May I proceed? Okay. And do you recognize, just sort of comparing, I know it's difficult because that plan, applicant's Exhibit number 2, is small, as is this. But you agree with me that the area depicted on Exhibit 2, where the infiltration facility is this area that in part is covered up with concrete and in part sort of indicated as bare ground. So doesn't that suggest to you, Mr. Richardson, that the infiltration device that applicants say has to be here, has to be in this location, and is the basis for its variance request? Doesn't this indicate to you that that's not the case?
The fact that he hasn't built it yet, that doesn't mean anything.
Well, he wouldn't
He can't get his money back from Baltimore City until he builds the thing in accordance with the plan. He has to comply with the stormwater management requirements.
Well, this house has been,
And it's also been
Occupied-
in court since
One at a time,
2017 as well.
no, I understand. I don't want to
He
talk.
may not want to spend the money to put it in yet.
Well, we'll put it this way. Are you aware of the fact that this house has been occupied for the last couple of years?
Again, I'm going to object. This goes way beyond the scope of what we're here for. We're here to talk about why the landscape infiltration facility was placed on this plan at the time, years ago. That's the issue that the court has specifically identified. We're not here to talk about whether or not the house is occupied, whether it's been built yet, et cetera.
Go ahead, Mr. McCann.
Thank you, Mr. Fields. Isn't it true in Baltimore City, in order to occupy a house, you have to get a use and occupancy permit?
Probably is.
What we in Baltimore County call a
Yeah,
use and
yeah,
occupancy
yeah,
permit.
uh-huh.
And in order to do that, and in order to begin construction, you need a building permit, correct?
You need a building permit.
And in order to get a building permit, you need to get your stormwater management plans approved.
Correct.
Okay, so those plans were approved, a building permit was issued, the house was constructed and is now occupied in, but that facility is not on this property, correct?
Doesn't appear to be.
Okay. Just a couple more questions. You mentioned that, and I think Mr. Fields was getting to this point as well, that this house in the garage is the only place it could go. Isn't it true that the property owner could have built a smaller house, smaller breezeway, a smaller garage or no garage, and constructed that house on this property in full compliance with the 40-foot setback? Isn't that
Again,
true?
I'm going to, just to preserve the record, I apologize, but I'm going to object. We've already recited Mr. McCann's position about being able to build the exact same house and move it back, and now we're getting into, what if you build a smaller house or a different house? We're talking about this house. He's already made, he doesn't get to change his argument halfway through the many years we're going through this. So I'll just object for the record. Thank you.
Go ahead, sir.
You can answer, Mr. Richardson. I'll repeat the question if you want.
You can build anything that would fit within whatever.
Okay,
But
so
this is not this house on this lot.
Bear with me one second. In terms of the soils on site, if we could talk about that for a second. These are what are known as B soils, correct?
Yeah.
Okay. And in the city and in the state, in fact, there are A through D categorized soils, right? A is the best. A is the most permeable.
Sandy, permeable materials, yes.
Right. A is the best in terms of permeability, that is, rainwater is allowed to seep through. B is pretty well draining soils, is it not?
Yes.
And I don't know how much familiarity you have with this area or the city, but B soils in the city are relatively rare, are they not?
Most of the soils in the city have been disturbed, so they generally don't classify them as B soils.
Okay. And so if soils have good permeability, as these soils do, that actually gives you more options for the practices that I was describing earlier under the design manual, correct?
Gives you the ability to do an infiltration trench like they're doing here.
And other things as well, correct?
Infiltration trenches and infiltration landscaping, yeah.
Okay, but lots of things, as you described earlier, right?
I don't know, not sure what other things you're going to use for infiltration, but
Okay. Sorry for the delay here, let me just make sure. Okay, that's all I have. Thank you, Mr. Richardson. Thank you.
Just very briefly, Mr. Richardson, Mr. McCann was talking a lot about ESDs. What's the label of this facility here? Is that ESD?
it's an ESD.
So this is an ESD, correct?
Correct.
And based on your expertise, is this the type of landscape infiltration facility and stormwater management treatment facility you would build and is required by this site at that location?
Yes.
Thank you. Nothing further.
Very well, thank you, sir.
That would be our case in chief. I'd like to reserve maybe just a few minutes in rebuttal if necessary. Thank you.
Absolutely, Mr. Wallen. McCann?
Thank you. Thank you. Ms. Taylor is handing up some binders. These are just several exhibits that I'll offer into evidence, and I have a copy for Mr. Woolman as well, Angela. Okay.
You can just,
I should have handed it to you.
no worries.
Okay.
Thank you.
May I proceed, Mr. Fields?
You may.
Okay. Listen, I wanted to, I know we've been before you guys a couple times. It's been so long you probably don't remember me, but I do not disagree that this is an unfortunate situation all around. It really is. It's unfortunate the board's time is being taken up once again. It's unfortunate, frankly, for Mr. Naylor himself, who by all indications didn't do anything purposefully wrong. But it's also certainly unfortunate for my clients who have had to live, and their neighbors, and I'll introduce a number of letters, who have had to live next door to this house, which is jutting out clearly into the street, much beyond the others. But the law tells us that none of that, frankly, is relevant. It doesn't matter whether Mr. Naylor, the property owner, knew he was violating the law. Ignorance of the law, as you know, is not an excuse. Mr. Naylor is presumed to know the law, and he should have known about the setback. It's that simple. And maybe more importantly, his professionals, his architect, his engineer, his builder should have known about the setbacks. Certainly about, not only about the 40-foot setback, but you may recall, Mr. Fields, that there was also an 82-foot setback that is in the recorded site plan for this project, in the recorded subdivision site plan for this project. So just as a matter of background, I included in my exhibits, exhibits B, C, D, E, and E. Those, there's the the deed to that was given to Mr. Naylor that makes reference to the subdivision plat that I just spoke about, the 82-foot setback, the subdivision plat itself, which is Exhibit B, some covenant agreements entered into with my clients, among others, way back when, that imposed that 82-foot setback, and as well as a policy of insurance that Mr. Naylor took out that makes reference to that subdivision plat as well. So with all that background, let's get to the heart of the matter, which I would agree with Mr. Woolman is, can this infiltration facility, or more appropriately, can any stormwater management go anywhere else on this site and allow this house, as I've said 100 times, to be pushed back, the very same house, be pushed back, and the garage, 10 feet without disturbing the forest conservation area in the back. And on that issue, I will call our first witness, which is Mr. Dan O'Leary. He's a stormwater management expert. Okay. Mr. O'Leary, tell the board what it is that you do.
I'm a civil engineer, a registered professional engineer in Maryland, specializing in water resources engineering.
Okay.
Hold on one second.
Sure.
Has anybody been sworn?
I don't know that any of these folks have been sworn in this matter. You know what? If, and Mr. Woolman, if you would agree, I don't think your witness was sworn either when we started. But I think what we're going to do is, if you agree and your witness agrees that he's agreed to testify under oath and the whole truth, nothing but the truth, in all the testimony that he's provided today. But if you wouldn't mind, I'll just have him come up and swear, and we'll make his swearing in and your other witness swearing in retroactive to the beginning of this hearing. Apologize for that.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you.
And again, I'll accept a representation from counsel, Mr. Woolman, that his witnesses have, of course, testified in accordance with that oath.
Thank you, Mr. Chair.
Go ahead, sir. Sorry to interrupt.
It's okay. Thank you. Mr. O'Leary, what do you do for a living?
I
think you answered that already.
I'm a civil water resources engineer.
Okay, and does water resources engineer mean essentially a stormwater management expert?
Stormwater management's included, yes.
Okay. And do you have a college degree?
Yes.
Are you a licensed engineer, you indicated, correct?
Yes.
Okay, and describe your practice.
For the last 35 years, I've been a regulator. I worked as the Plan Review Division Chief at Maryland Department of the Environment. in the Sediment and Stormwater Plan Review Division. Since 1996, I've been in private practice as a consultant, working on various state and federal projects. Since 2002, I've been a consultant working on state and federal projects, as well as design of site plans for stormwater management and sediment control permits. And since 2002, I've been in, well, actually earlier than that, I've been an approved expediter. So I review plans on behalf of Maryland Department of the Environment and on behalf of Baltimore City Department of Public Works.
So on behalf of the city, just so we're clear, you review the very type of plans that we're here for today? That type of
That's
plan?
correct.
Okay, and you've been doing that for a number of years, you said?
Yes, the city reviews since like 2003.
We mentioned during my questions of Mr. Richardson, the Maryland Stormwater Management Design Manual. Are you familiar with that?
I am.
And do you agree with Mr. Richardson that that is the standards that apply in Baltimore City?
Yes.
As well as elsewhere in the state?
Yeah, the city has some of their own requirements in addition, but the MDE manual is the basis.
Okay, that design manual, were you involved in any way in the drafting of that manual?
I was on the committee that reviewed the drafts and provided comments.
Okay. Have you been to the site that is on Roland Avenue?
I've been on Roland Avenue and viewed the site, yes.
Okay. Did you review the stormwater management plan that Mr. Richardson was shown, which was applicant's number 2?
Yes.
And it's also, just for your reference, it's also our Exhibit I. Did you review those plans?
I did.
Okay. Great. They're a little out of order. I apologize to the board. The last page in Exhibit I is really the first page of the stormwater management plan, which is the same page that Mr. Woolman showed you guys. Under the manual, the design manual, is there only one way to provide stormwater management, or are there multiple ways of doing it?
There are multiple ways.
Can you describe for us that a little bit?
Well, since 2009, when the legislature passed the revision to the Stormwater Management Act, Chapter 5 in the design manual was revised to include a menu of different options for meeting the environmental site design requirements.
ESD.
ESD.
Okay.
And you can choose one if it works for the site, or you can choose multiple approaches to aggregate them to meet the requirements.
Okay. Do you know how many ESD practices there are, approved practices in the design manual, roughly?
15.
Okay. So let's sort of cut to the chase here. The infiltration facility that we've been talking about, you familiar with that?
I am.
Okay. Is that facility, as this is depicted in the stormwater management plans, which is part of Exhibit I, our Exhibit I, is that the only way that stormwater management could have been handled for this project?
No.
Okay. Could you give us ways in which, let me focus that question a little bit more. If we were to take the existing house, the existing breezeway, and existing garage, just assume that all that's okay. You didn't have to make it smaller, but let's take all of that and move it back 10 feet, comply with the front foot 40 feet setback. Are there stormwater management practices approved by the City of Baltimore and in the design manual that would have worked for that site?
I believe there are, yes.
Okay. Could you tell us what they are?
Well, for one, we've already established that there's well-drained soils on site, so permeable pavement is one way to reduce the overall need for storage, stormwater storage on site. And you could address the driveway and parking area with permeable pavement.
Describe what that is. I think it's obvious, but what is?
It's pavement that allows rainwater to soak through, and then underneath the pavement is a stone reservoir that fills up with that water that soaked through, and that gives it time to soak into the ground. So it's essentially an infiltration device, much like the landscape infiltration that was proposed.
Just an alternative.
It's an alternative, yes.
Anything else?
Well, then you would have to treat the rooftop runoff that drains to the landscape infiltration, and you could do that either with a dry well, which is similar to what's on the front of the property, or a cistern, where you would use, capture the rainwater in a tank and potentially use it for watering grass, flowers, a reuse of rainwater.
Okay, so when you say handle the runoff, am I correct that the way stormwater management works is you've got to take all the expected rainfall on site, and you've got to handle it some way, right? A certain level of it has to be handled in some way.
Yes.
So you mentioned dry wells. What is a dry well? What does it look like? Where can it go?
Well, as Mr. Richardson said, it's basically a pit or a hole in the ground of a prescribed volume. And the rainfall of whatever inch, I think in this case they use 1.8 inches of rainfall, you convert that to a volume, a runoff, and that's the volume that you need to provide in this underground storage in a dry well.
In fact, under the stormwater management plan that we've been talking about, that's applicant exhibit number 2, there is a proposed dry well on the front lawn of this.
Yes, there is.
Of this site plan.
That's correct.
So are you suggesting we could make that bigger, or what are you suggesting is in terms of?
Or
dry
you
wells?
could, if you move the house back, there would be room to add another one, potentially to address the runoff from the roof.
Okay, and then you mentioned cisterns, what's that?
A cistern is essentially an underground tank or a surface tank
Mhm.
that would be of a prescribed volume, would receive the runoff from the rooftop, and then be used for various house, around the house uses, whether it's watering plants or simply releasing it slowly.
Okay, so under the scenario I just described where we move everything back 10 feet, there's enough room on site to do those things that you just described
Yes,
without interfering with the forest conservation area?
that's correct.
Sir, may I ask a question?
Yeah, sure.
What, if anything, can you tell us about the relative costs of these alternative mechanisms that you've described?
Porous pavement is likely more expensive than the landscape infiltration.
Do you know about by how much?
I would prefer not to guess in front of the board.
I have a question. Do you have any drawings that show what you're proposing?
Well, it would essentially be the same footprint of the driveway that you see. It's just the driveway would be full of holes and there would be stone underneath it. And then,
You were talking about cisterns and other options also. Do you have any drawings showing any of that?
no, I haven't.
All of that?
I have not prepared drawings, sir.
Thank you.
But any doubt in your mind that those things could be done on this site without interfering, and allowing the 40-foot setback on the front yard?
No doubt.
Okay. As an alternative, let me just show you again, excuse me, I'm sorry. I'll back up, actually. I'll back up. Sorry. So here again is the infiltration area. Would it be possible, in addition to, not having this at all, would it be possible to have this, move everything back, have this, but just use a little, some area of the parking entrance to the garage for that infiltration? Do you follow me? So let's say, let me just make that question clear. Let's assume under my scenario again that we moved everything 10 feet back, the house, the breezeway, the garage, so that it was not in but near the forest conservation area. Could you do this same infiltration facility in the same general area, just use some of the space that's presently indicated for the entrance to the garage?
It's possible to reconfigure it. I don't know if you could do it to completely eliminate the need for it behind the, between the pavement and the easement.
Yeah.
Certainly you could reduce the amount of pavement, the size of the pavement, and absorb that. You would just
In other words, you, for example,
lose
you could-
parking area.
Yeah, you could have a two-car garage, and that
Or
would allow,
two-car garage.
and that would allow more room for that facility, correct?
Mm-hmm.
Okay. All right. I think that's all I may have, Mr. Fields. I just wanted to, sure. Okay, thank you, Mr. O'Leary. No other questions, that's it.
All right. Your election cross-examination,
No
sir?
questions.
Okay.
Okay.
Thank you, Mr. McCann.
Just use the balance of my time, if I could, just maybe
Sure.
sum things up for the board, if I could.
Certainly.
So, at the risk of repeating myself, I think the evidence, frankly, is clear after all this time that we could make this, construct this very same house, move it back 10 feet, and handle stormwater management otherwise. I wanted to point out, though, that there's no right to a house of this size. There's no right to a garage of this size, and simply because it is there now is not really part of the board's analysis. In fact, what the courts instruct us to do is ignore the fact that unfortunately it's there, because what's there cannot present the difficulty. Mr. Naylor cannot stand up before you and argue, I have a practical difficulty because this thing has already been constructed. If that was the case, variances would mean nothing. People could construct things on their property and avoid all setbacks. So the fact that it's there cannot create the practical difficulty. So without the requirement that the stormwater management facility be where they say it needs to be, without that requirement, there is no practical difficulty. And I think if you read the Circuit Court's decision and the Court of Special Appeals decision, I think that's frankly precisely what they were getting at. And I don't think either of those courts would be surprised by the testimony we've heard this afternoon. So with that, and I should add, there's been no testimony in terms of practical difficulty that this particular size, 6,000 square foot house is required to be there, that it's needed for some particular purpose, that a 3-car garage is needed for some purpose. So without that, I don't believe practical difficulty has been established. So I thank the board. I want to make sure that I've identified all the exhibits. There's a table of contents, A through I. I don't think I need to add anything to them. So with that, I'll sit down and thank you very much.
Thank you, sir.
Appreciate it.
Mr. Woolman?
Thank you, Mr. Chair. I'll be very brief in rebuttal. I was biting my tongue to object more, and I figured I objected enough regarding the scope of this hearing. I didn't want to be rude to Mr. McCann, but the last arguments he made are just not before you. And the Circuit Court made that very clear in their decision. The practical difficulty issue under the law, which is the McLean factors that the court referred to, again, page 10 of the Circuit Court's order, while the board didn't specifically identify the 3 McLean factors in its resolution, it did address each factor. You guys have already done your job on that. The only thing we're here for is the placement of the landscape infiltration facility. And if I may, in brief rebuttal to the expert testimony, have Mr. Richardson stand up and answer a couple of very quick questions regarding what we heard from Mr. McCann's expert. And Mr. Chairman, I think you were already picking up on one of them. Mr. Richardson, it's my understanding that, and you've already alluded to this, that there are multiple ways to address stormwater management, correct?
There are.
And it's possible to do something other than a landscape infiltration facility. Is that correct? It's possible.
It's possible, yes.
Is there a practical difficulty in doing something other than the landscape infiltration facility that was done on this plan? Is there a practical difficulty to do one of these other things that you just heard about?
Well, some of the things, like particularly porous paving, is discouraged by Baltimore City.
Sorry, what was that, sir?
Porous paving is discouraged. We get a lot of pushback if we try to come in with a porous paving design, particularly as close as it is to this house with the paving there.
Why is that discouraged by the city?
They don't like porous paving that close. It puts water in close to the foundation of the house, for one, and porous paving is basically, it's a very high maintenance type of thing. It's expensive to install and it's expensive to maintain. Most people won't maintain it, particularly a homeowner, and so to get it to work and function for long term, it's really just it's not a great practice. It is a practice that the state of Maryland does allow, but we generally just don't use it very often.
And what about some of the other possibilities that you heard about, dry wells, cisterns, things like that?
Well, dry wells could work for the house potentially. You can do rooftops into them. You can't use those for paving, I don't believe. And like a cistern, you have to have a place to put the cistern, and you have to have a use for the cistern water. And I don't know that most people are going to do that. I just generally try not to do that. I look for things that are low maintenance and relatively low cost when we design for our facilities. And this landscape infiltration is definitely one of those lower cost, lower maintenance type of things that you would install on a house.
And again, understanding that you weren't the project project engineer, if you were designing this site, would you have designed a landscape infiltration facility in the same location, the same size that you see on the plan here today?
I probably would have. Given if the fact that the soil is infiltrated, which they did, this is the best, I think, the best solution from my perspective, my opinion.
And again, just one last time, do you see a practical difficulty then with placing this landscape infiltration facility or implementing one of these other techniques somewhere else on the site?
Well, the facility has to capture the water that's leaving the direction that it's going, so it has to be in the rear, and this is the only place it can go. And like I said before, if you try to cut down on the paving for the garage, you're basically going to eliminate the accessibility to that last garage door, so you might as well just say you're only going to have a two-car garage as it is. So I don't think you can reduce the paving. I don't think you can reduce if this is the house that the gentleman wants to build, you can't reduce the size of the house, you can't reduce the paving, you really can't move it anywhere. In my opinion, this house needs to go where it's going for all those reasons.
And finally, would you agree with Mr. McCann's statement that this house could be moved back 10 feet and comply with all the requirements of the forest conservation easement, the utility easement, and stormwater management?
I disagree with that statement.
Thank you. Nothing further.
Why do you disagree with that statement?
Because you need that space. You need the space for the stormwater. You need the space for the paving and the house. It just fits in that space. Unless you make something smaller. You can't make the stormwater smaller because the requirement is the requirement. You have to have a certain surface area for the facility in order to make it function and work for the design that it was proposed. So you're left with reducing the size of the structure, basically, if you could do that. That's not my field.
Okay. All right, thank you.
And in summary, I'll just, to follow up your question to Mr. Richardson about doing something smaller, again, the petitioners have always argued, and I'll quote from the Circuit Court opinion, that the exact same house and garage constructed by respondent could be moved back 10 feet in the lot and thereby comply with the required 40-foot setback without any impact whatsoever on the utility easement, the forest conservation easement, without the need for any variance at all. You heard Mr. Richardson's response to that. I would submit that that just cannot happen. So it's the only place to put this facility. That's the only issue before you, and with that, I'll submit. Thank you.
Thank you, Mr. Wong. Appreciate the presentation. Thank you, Mr. McCann, as well.
I know it's the board's practice has been to deliberate immediately after, but given the number of people that we have waiting and the amount of materials that the board has, I would suggest that we wait to do this one at the end, because I think it's going to take some more time.
Thank you. I agree. Calling the case of 2022-154, 5718 York Road. AB Associates is the appellant.
Second from there. They're doing this new Terra Cafe second.
Yes.
You might know that somebody should probably look at the council person. I think I saw her. She's down there.
Is she for New Terra Cafe?
Yeah.
Can we actually call the 28th Street next? The councilwoman is here and has that hearing.
Okay.
If you don't mind.
Sure. False alarm,
That's fine.
Mr. Berry.
Which one are you
Sure,
calling?
let's call it. We're going to call 2021-217, 101 through...
2021-254, 1503 East 28th Street. I'm sorry.
Okay. Let's do that. 2021-254, 1503 East 28th Street. Kushal Gupta, the appellant. This is a request to use the premises as 2 dwelling units.
That's correct, Nate Predel. And the applicant is here, and he just ran out, but we're going to continue and move forward.
Okay. We're going to have to swear that applicant, I guess.
Yeah, if he makes it back in time.
All right. Well, you can proceed.
Could you state your name, please?
Nate Predel.
Thank you.
Swear in.
And I'll hear from planning and staff on this one.
All right. As was previously mentioned, the Planning Department, by memo dated October 28th of 2021, recommended a disapproval of this application on the basis that bear with me. It was authorized for use.
Can't hear you, Martin.
I'm sorry. This property was authorized for use by the board in 2010 for use as 2 dwelling units, but that there is no record indicating that the applicant actually obtained a use permit on the basis of that record, that the board granted approval of 2 dwelling units. And because of that, there's no evidence that the property was lawfully established and continually occupied as 2 dwelling units. Department also noted that the Coldstream Homestead Montebello Area Master Plan calls for increasing opportunities for home ownership, rehabilitation of vacant homes and new construction, rehabilitation and preservation of existing housing stock in areas of strength. This particular property had remained vacant for an extended period of time under an ownership that had not changed. And therefore, the department recommended disapproval. First, because it was not eligible for a residential conversion from a single family to a multifamily, and that the amount of lot area variance needed for approval was excessive in relation to the standards provided in the zoning code. The department also wished the board to note that allowing use of this property as a multifamily dwelling would not contribute to efforts to strengthen the Coldstream Homestead Montebello community in a manner consistent with the goals expressed in its community-supported master plan. Thank you.
So this one in particular is to use as a multifamily dwelling. So the board may recall that we had this one actually before the board, and it was disapproved because at the time we could not find a legal use and occupancy for anything other than a single-family dwelling. This came back, the applicant was able to find a issued use and occupancy permit as an MFD from 2010. We went back, did some additional digging and research, and also discovered that the city issued, or Department of Housing and Community Development issued a use and occupancy permit using entire premises for 2 dwelling units, first floor dwelling, 1 dwelling unit, second floor, 1 dwelling unit. The permit itself was issued on August 26, 2010. So the last legal use that we had for the property was as a 2 dwelling unit. So this is why it is back before you. The information we had the first time was that it was single family, and then to do anything other than that would be a conversion. So upon the discovery of that permit, that's why this case is back.
Okay, thank you.
And if the board were to grant it, really the issue is if it is two dwelling units, it would be minimum lot area variance, 3,000 square feet is required, 1,168 square feet is provided, so it's a 1,832 square foot variance requested.
Okay. Great. Go ahead, Mr. Pro.
Afternoon, Mr. Chairman. Nate Predel here on behalf of the applicant who may join us in a minute. And Ms. Byrne did a pretty thorough job of summarizing what my testimony was going to be. This is just to give a little more background. This property has been a lawfully used multifamily.
Hang on.
We gotta be
We'll get this right.
Okay.
We're going to
Gotta
swear
swear in.
both of you.
All right.
Since you're testifying and we don't have the applicant, and we're going to have to swear your...
That's fine. If I may just ask, I think we can handle it without him. So.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
do.
Thank you. Could you state your name, please?
Councilwoman Odette Ramos.
Thank you.
Go ahead.
Okay, I'll start from the beginning. I think, as I said, Ms. Byrne, I believe, has done a thorough job summarizing what is sort of the core of the testimony I'll provide, and I'll be brief on this today because I think it is pretty simple and straightforward. But to provide some additional background, this property has been operated as a 2-unit multiple family dwelling since 1969, and you can look back at the board's resolution approving the continued use of this property as 2 units from 2010 even reference that, and it grants a permit number saying, so there's no dispute that this property has been used for 2 units for at least 52 years. In 2007, the property went vacant, and the prior owner came before this board in 2010 to request the continued use of 2 units. The physical characteristics of the property have not changed, as a whole, and the layout has not changed from this 2 units. They were granted approval from that 2 units, and subsequently on August 26, 2010, obtained an occupancy permit. Mr. Byrne read the language into the record. It was per BMZA 97-2010, continued to use premises as 2 dwelling units, and that was issued by the Department of Housing. And that's, at that moment, that's the lack of availability of that record is what led to us even coming back to the board. My client, Mr. Gupta, Kushal Gupta, if you want to, maybe we'll swear him in.
Yeah, let's do that, please, just so the record's clear.
If you raise your right hand, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you.
So when Mr. Gupta purchased the property in 2021, he did some very cosmetic repairs, not requiring a building permit, painting, just straightening up, and then went and filed for a new occupancy permit. And at that time is when zoning said, wait a second, we don't have any record of this, of you obtaining an occupancy permit after the first zoning board hearing in 2010, you have to go back to the zoning board. And he came back and was denied primarily based on the lack of that prior zoning approval being vested through an occupancy permit. At which point, I was brought in to sort of assist and look into this and was able to find this valid occupancy permit. And once that occupancy permit was obtained in 2010, the prior owner, had tenants that occupied the building all the way up until Mr. Gupta purchased it. Once he purchased it, the tenants left. He did some minor cosmetic repairs, and we are here where we are. So, the variance is being stated, in my opinion. I don't even think that we're requesting variances. What I'm requesting is a confirmation from the zoning board that that occupancy permit was valid. If this would have, the occupancy permit would have been available for zoning and records when they were reviewing his application put in 2021, is my opinion that we would not even be here at this time. And I will say that I very much respect, the position of the community on this, and, I support their goals. However, this is a property that has been laid out here for 2 units for 52 years. We have an applicant who owns, how many other properties in Baltimore City do you have? 40 properties in Baltimore City. Sent me a list. I couldn't find a single violation, housing code violation. He's a reputable property owner here, and I'm encouraging him to work with Coldstream Homestead. I know there's some other vacants on this block that we would be more than interested in redeveloping as single-family dwellings, but for the case at hand here, it's my opinion that that occupancy permit sort of puts this to bed, and should that have been available when he was going through, filed a new one, we wouldn't even be in front of the board in the first place.
All right. Thank you, Mr. Prettle. Councilwoman.
Thank you, Mr. Chair, and thanks to this board for allowing to change the schedule. I appreciate it. As Mr. French said in the reading of the report from before, the goals of the community are to rehab this entire block and others like it for single-family occupancy. It is zoned R6, which means no single-family conversions. And so we're asking the board to take that into consideration. We didn't get notice of this hearing, so I've not been able to verify everything that Mr. Prettle said from our side. So I don't know, I know that most of the block is vacant. We do have a redevelopment plan in the community, and it is important for us to prioritize this block. There have been 2 murders there recently. And And so, but we do want to, the community is very clear that they're interested in single family. It is R6 zoning, period, and should be looked at in that way for this case. Thank you.
Thank you, Councilwoman. Reynolds,
Just,
final word?
yeah, I'll just close by saying, once again, I do sincerely support the goals of Coldstream Homestead Montebello in this situation, and actually have been working on a rezoning bill, nothing to do with this, that would further support that. But here we have, we have a housing crisis throughout the country and in Baltimore City, and we have a high quality, affordable 2-unit dwelling with a property owner who is responsible and reputable and operates without violations. And again, it's my opinion we shouldn't even be in front of the board. This was a record-keeping error, and I would urge the board to approve this request to continue to use this property. And just the last thing, in regards to a conversion, I think we're all very familiar with the conversion bill, but this in no sense is a conversion. It's not a physical conversion, and it is not a sort of a paperwork conversion based on my testimony that I provided.
How many other properties does your client have in Chum?
Where?
Coldstream Homestead Montebello.
I have another on this block, so I also own 1590, and then I also own Alameda. So again, and all those are single family, and when I hired Nate, I told him that my goal was not conversion. It was when I got it, it already had 2 electric meters, 2 gas meters. So it was my understanding that it was all set up in 2 units, and everything seemed to be in place. So it's not like I bought a single family and I'm trying to convert it into something. And I called VG, they said, yes, these meters have been there for last 20 years. So I checked all that. It just, I at that point. But all my other properties are single in Coldstream, and I plan on keeping it that way and not making it multiple units. I'm not a big builder. I'm just trying to have as many good rentals as possible.
Okay. Very well. Any other questions? No. All right. Thank you so much for your presentation.
Before we close, I just want to make sure, reference the use permit. I forgot to say that in the beginning. The use permit that was issued for the 2 dwelling units was use 2010-01809.
That's correct.
Okay. Thank you so much.
Thank you.
Thank you.
Do
you want to deliberate on this now?
Yeah.
Yeah.
So make sure to speak into the microphone as you deliberate.
You want to turn the microphone around?
Oh, yeah.
So our standard here is,
Well,
a minimum lot area variance.
But don't we first have to address the conversion issue?
Yeah. I don't think there's evidence of a conversion. Not
Me
on the
neither.
record.
Okay, so I'm just making sure.
let's speak into the microphones, everyone. So
Well, the issue raised by the opposition is that it's conversion. I think as a matter of law, based on the record, evidence in the record, there is no conversion here. This was a duly authorized and legally established multifamily dwelling, and we have the records for that. And so a conversion, I think, is not applicable here.
I agree with that.
Great.
So you should have the variance standards in front of you for the lot area variance.
Is the property unique?
Okay. Conditions on which the application is based, unique to the property. Well, again, this is a minimum lot area variance, right?
Yep.
So,
I have a question.
yes.
But for the non-conversion issue, would this have been the type of lot area variance that would be on the consent docket, or no?
It just depends on whether there's opposition.
Okay.
So a lot area variance basically refers to there are more, basically there's a requirement that each unit corresponds to a certain amount of lot area. So basically it's like it's denser than the code would allow by right. Things that are unique to the property, I think that Nate presented, I'm just suggesting some things, you don't have to accept this, but that the fact that it's already been a 2-unit for so long.
Yeah.
We had one like this 2 weeks ago that was similar in that they're not changing the physical structure of it to cover any more of the lot area, just as that's the size of the house, and the house is 2 units.
Yeah.
Okay.
And in fact, it would be impractical to break up the house in any kind of way to
Make it
fit
single
within
family.
the code requirements now as to, without a
Especially
variance.
because it's a row house.
Right.
You can't take pieces of it away.
Okay.
Okay.
So I believe it would present an unnecessary hardship or practical difficulty.
Yeah, of cutting the.
To, again, modify the house in some kind of way to
Yeah.
meet the requirements of the lot area variance.
And none of this is the owner's fault.
Nope.
The unnecessary hardship, it's practical difficulties caused by the code. The code says it requires X.
Correct.
You can't do that without having some difficulty, practical difficulty.
It is not based exclusively on the desire to increase the income.
I agree. That's no
Oh.
finding there.
The variance would not be I don't know how to say that word.
Injurious to the use and enjoyment of other property? No, it's been
No.
that way for quite some time, a number of years.
Yes.
Is the variance in harmony with the purpose and intent of the code? I think it is, given this particular property.
On this block.
Right, on this block.
At this time.
That-
Specifically also.
That has existed for multiple years. I don't think the code would impose on an owner of this type of property to
Correct.
modify it.
There's no urban renewal plan. I don't think that it applies to the comprehensive master plan, this size.
Actually, there is an urban renewal plan, which is why I would like to be able to vote against this, but on the other hand, it's a legally established use, and I'll have to vote in favor of it.
There's a Chum urban renewal plan, you're saying?
Yes, there is.
Okay. It's not in a CHAP district, though.
No.
And the variance is not detrimental or would not endanger the public health, safety, or welfare.
Okay. Great.
So, those findings, take a vote. I'm a yes.
Yeah, I'm a yes.
I'm a yes.
Great, thanks.
Okay, which one did we just do? I just did.
York Road, 254.
Okay.
Yeah, you called the York Road one.
Sorry about that. All right, Mr. Barry, we'll call you back. We're going to call the matter of 2021 dash, let me just use, what did I call before?
You forgot what you called them for?
2022-154, 5718 York Road, AB Associates. And this is seeks to consolidate 5718 York Road and 5717 Bologna Avenue and use portion of rear as a patio. Is that correct, sir?
That's correct.
All right. I'll hear from.
Swear the witness.
Thank you.
Good old swearing. Let's do that. Sorry.
Would you both state your names, please?
Alfred W. Barry.
Carpenter.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? so
I do.
Okay. Planning and staff?
Planning Department has no comment on this application. Thank you.
The request is an interior side yard setback, 10 feet required, 3 feet proposed, 7-foot variance is requested. For the tricky issue with this particular property is that the York Road property that's going to be consolidated with the Bologna property, York Road is C2, Bologna is R3. If in normal circumstances, the use of the patio for outdoor dining is permitted in C2, but not permitted in R3. The outdoor dining in C2 requires an alley access, but when they consolidate the two lots, the rear now will be street frontage. So the access that would have been required by an alley could be met by the street frontage. So The tricky part is where the line is drawn, and essentially what would be permitted at the property.
Okay. All right. Mr. Berry?
Yes, thank you, Ms. Byrne, for that. This is an unusual case that comes before the board due to a discovery of a mistake that was an assumption, frankly, on our part. As was stated, the York Road property is a commercial property. It's zoned C2. It has a valid building permit to have a light manufacturing food production facility, a restaurant, outdoor seating with a valid permit. I'm here with Shane Carpenter, who's the operator of Hex Ferment. Hex Ferment is a established York Road business that had a retail facility on Belvedere Square and a production facility at the Accelerator Building a few blocks to the south. They bought both properties, the Bologna Avenue property as well as the York Road property, with the intent to consolidate them into this facility, which they have a building permit for and a recent occupancy permit. However, the Bologna Avenue property had, since 1950, in the 1950s, we found a city council ordinance that took that residential property into a commercial parking lot. It was used as a commercial parking lot and paid and used by various businesses on York Road. The adjacent property to the south is a restaurant building that has a commercial parking lot, and that also goes to Bologna Avenue, and that's used by that, and that's zone C2. Frankly, I think there was a mistake in Transform Baltimore in not recognizing the commercial parking lot and giving it the residential zoning that it has. However, the property was under construction, it's completed. The patio that you're going to see, I'm going to hand out examples of the site plan, below with the site plan. Thank you. That shows the extension, a 350 square foot extension of a patio into this residential zone portion, but once it's consolidated, it meets the standards for what's called an accessory use. An accessory use is a use which is clearly incidental to, subordinate to the main building, which is over 5,000 square feet, and will be accessed essentially from the York Road building. In addition, the site plan shows, which is really not a use per se, a loading ramp that is also partially in the residential portion, and that's part of this approved building permit. Now, one of the things that we looked at, and I'll pass these out as well, this is a survey. We wanted to compare the dimensions of the zoning and find out why this mistake could have happened. Well, the owner, basically, when he bought the property, there was a parking lot and a fence. He assumed the fence was the rear property line. That fence is about 50 feet away from the rear of the building that is not being expanded to the rear. The rear of the building is the rear of the building. They've built an addition which comes up to that as well. So they had these plans proposed for a 25-foot, essentially, patio that was within the 50 feet. However, during the consolidation request to the city, it was discovered that the property line was actually further in. And that's why there's a little bit of an intrusion. Then I went to take it even further. I compared the city block plats to the zoning maps and the survey and what's in the field, and they're all, nothing conforms. There's as much as of a, for example, the 5717 Bologna Avenue property, the block plat shows it as 122, the survey says 119, 57.7, and it's a diagonal. Part of the reason for this is that there's a diagonal line for the fence, there's a diagonal line for the property line, none of which is parallel to anything. So who knows where those came from? That part of York Road is a toll road, is a very historic property. The block plat shows 5717, one side of it, 'cause again, it's a diagonal, 115. The survey shows it at 109. So you're talking about big differences, and the zoning maps aren't dimensioned. They're not dimensioned. You look at them online, and you have to guess where the zoning line is. My presumption is it could have been the property line, wherever that was. So with that in mind, we have a use which has had support since 1920. I'll put this in the record as well. 2020, from the two York Road Partnership, I guess, and the Business Town, Gomez Business Association. We have approval of, again, as a restaurant for this. All we're asking is that once we consolidate, the board, if they approve it as we submitted it, this becomes an accessory use to the York Road property, and hopefully everybody can go home and be happy. So.
Okay. All right.
We have the owner here. He has a very interesting business, by the way, that's been established. Mr. Carpenter, if you want to talk about what you do.
Sure. Yeah, we've been familiar with the corridor for some time. As Al mentioned, had a shop at Belvedere Square Market for 7 years, closed the day the governor closed Maryland in 2020. And then for the past 6 years, we've been at Bologna and York Road making traditionally fermented foods. So we source from Maryland and Pennsylvania farms and transform those into sauerkrauts and kimchi and pickles, various ferments, including kombucha. So good for your gut and good for the local food economy as well.
Okay. Very well. Any questions of Mr. Berry or the applicant?
No.
All right. Mr. Berry, is there anything else?
Nope.
Okay,
Thank you.
very well. Thank you for your
I think you have
presentation.
sufficient, hopefully you have sufficient evidence to approve it.
Okay. Thank you, sir.
Thank you.
Thanks. Thank you.
Okay. This is 154. Minimum interior side yard setback.
So Katie, do they have to approve the accessory outdoor dining use as well, or is it just that one variance?
So it could be the variance, but the variance conditioned upon, I think it's important to recognize the accessory, because if you don't recognize it as an accessory use, then you're saying that the outdoor dining on the R3 is primary, right? So I think you can get there as long as you identify it as being accessory. I don't think it has to be, it needs to be a finding of fact.
Okay. Well, based on the presentation of Mr. Berry, I do find as a fact in the record that the property that's at issue here is an accessory use.
So I think he gave everybody the site plan, and you can see the dividing line on the site plan.
We got two. We've got 5717, 5718.
You look at this one.
Better than
This is the easier one to look at, where you have the seats. See how like the diagonal?
Yeah.
So one side is York, one side is
Bologna.
Bologna. So this is the Bologna side, which has the parking lot, and this is the York side, which has the business. So this is the portion that would be in R3, but everything is fed from that side. So it would be an accessory use, but it's going to all be one property. So everything is
Right.
consolidated. So the only split now would be a zone. So this would be R3, this would be C2. So then you can have an accessory use that supports, under the code, you can have an accessory use that supports a primary use. And you wouldn't have to establish the patio as the primary use in R3.
Okay.
If that makes sense.
I don't think there's any way that that's not an accessory use, a parking lot and half a patio. Has to be an
Accessory
accessory
use
use to
to-
the main restaurant.
In the beginning of the patio.
Yeah,
I
especially
think-
because at one table, at least 2 of the chairs are in another zone, so.
I think the record does show, and this plat, or this site plan does show, the primary use is in C2 as the restaurant with, the beginnings or half of, the patio, and that simply continues. I don't think the section that is zoned in R3 would be a standalone use. It's necessarily, it seems to me, on the record, accessory to the property that's zoned in C2.
And what was the adjacent property zoned on the Bologna Avenue side?
R3.
R3.
So they're all R3.
The York Road side is C2.
I'm talking about the adjacent
Oh, oh, oh.
properties.
No, I don't think they are. So let me.
I thought I heard they were C2.
Can we ask him?
I can pull it up for you to tell you what the neighboring properties look like in
Yeah.
code map, if that would, is that what you're asking?
You may have that in your file as well. Usually there's a zoning map that has the different colors showing the different zoning districts.
Can't even bring that up.
And I asked that because I would think this would also be within the intent of the city code.
Part of what Mr. Berry, I understood him to be saying is that all along that street, things got zoned in a weird way that wasn't necessarily, like, congruent
I
to.
thought that's pretty much what I heard also. The
Yeah.
adjoining properties C2.
So on the Bologna side, let's see, 5716 is zone C2 all the way through. So it's York Road, 5716 goes all the way through to Bologna is zone C2.
So this is a weird R3 carve-out, kind of, in the middle, like a little poke-out, kind of,
It's,
to the greater R3 that's behind it, that is the neighborhood?
there's some on Bologna, there's residential across the street, and there's
Yeah.
residential on the side right next to it.
So one side of this lot is C2,
C2, the other side is R3, yeah.
Okay.
Okay. All right, what are these other things we have to find?
I do still see it as accessory and not because of the other C2 next to it. I don't see it as in opposition to the code, but that might be jumping ahead of our list.
No,
It's not?
I mean, that's a fact, we can find it. All right, let's just run down the list here.
So, okay. You want to do it?
No, go ahead.
Okay, let me hold your cheat sheet. So, I think the conditions are unique to this property because it is one property that's zoned in 2 different ways despite, sharing a whole patio area. The physical surroundings, there'd be an unnecessary hardship or practical difficulty if it stayed the way it is, because that is the parking lot for this building. And they wouldn't be able to make any use of that as a residential area because it is a parking lot. The unnecessary hardship is caused by the code because of how it is zoned and the differing zones for the lots that are next to it. The purpose is not based exclusively on a desire to increase the income. The variance would not be injurious to the use and enjoyment of other property, given that it is in a commercial corridor and there are other restaurants and such next to it. It is in harmony with the purpose and intent of the city code because there is another C2 right next to the part of this lot that's R3. I don't think that there's an urban renewal plan to be in harmony with.
There's no evidence in the record.
You said what?
There's no evidence in the record.
No
of
evidence
one.
in the record of that. There's no evidence in the record that this is in contrary to the city's comprehensive master plan or to anything traffic related. And the variance would not be detrimental to public health, safety, or welfare. If anything, it would increase that so that you can park next to where you are going and not have to cross the street, cross York Road, and get hit by a car.
You don't have to put that part in.
Okay.
Any resolution.
Okay.
All righty.
Yeah.
Thank you.
Can we vote?
Yeah.
Based on that record, I'm a yes.
I'm a yes.
Yes.
I'm a yes.
Thank you. Okay, let's go to case number 2022-147, 1916 Utah Place, Michael Castagnola. This is a request to use the premises as a multifamily dwelling consisting of 8 dwelling units, variance required for off-street parking.
How you doing?
Good,
We wanna-
thanks. Let's get everybody sworn.
Do we have opposition here for this? Opposition testimony? Okay, just, if you're here to testify in this matter at all, everybody please raise your hands.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you.
All right. Okay, can we hear from planning and staff with regard to this property?
Thank you. Planning Department reviewed this application, noted that this property is in the Bolton Hill Historic District, which would require that any exterior changes to the property would need to have approval from the Commission for Historical and Architectural Preservation for an authorization to proceed. The application was for 8 dwelling units. The department considers that amount excessive in terms of the variance that would be required for approval, which would be 31% variance. The department notes that requiring 6 dwelling units would require a 5.5% variance, which the department would not have an objection to. The department, therefore, is recommending disapproval of this application for 8 dwelling units because the amount and proportion of lot area variance required for approval is excessive in relation to the standards set forth in the bulk and yard regulations of the zoning code. The department would have no objection to approval of a 5.5% variance of lot area to allow converting the existing office space into an additional dwelling unit in this multifamily building, subject to the condition that all exterior changes, including additions, demolitions, and alterations, are completed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
So you're okay with how many units?
6.
Thank you.
So again, this is a variance for 8 units. The variances required would be for 3 off-street parking. 3 spaces are required, 0 are proposed, so it's a 3-space variance required. Last authorized uses is a multifamily dwelling with 5 units. History of the use that we found in land use records, 8 dwelling units in 1956, 7 dwelling units in 1969, 6 dwelling units in 1974, and 5 dwelling units in 1982. The application states that the current use is 5 dwellings plus an office. However, we could not find anything in the city records regarding an office use at this address.
Okay. Who do we have?
Hi, this is Michael Castagnola. I'm here with the owner of the property, Jamal Lee. Thank you to the board for hearing us today. So this property has sort of a long and peculiar history, and Jamal is seeking to restore this dilapidated building that was poorly managed into a contributing and thriving neighborhood asset that is directly aligned with the city's comprehensive master plan and the neighborhood's plan, the Central West Baltimore Choice Neighborhood Transformation Plan. The history of this building, as Ms. Burns shared, is that it at one time allowed 8 units. I think what is unique about the story of this building, though, is that from the time it was allowed 8 units to today, with its 5 units, it has always and consistently had 8 bedrooms. There's only been 8 bedrooms, whether it was 8 units, 7, 6, or 5. It has allowed 8 bedrooms, which I think is critical. The building also has, in its current formation, it has been chopped up and changed around and reconfigured across that time period, and currently has 3 units and 3 duplex units. Originally, my client was seeking to turn this into an 8-unit building, but we've had multiple meetings with both the Madison Park Improvement Association and the Bolton Hill Community Association, who have expressed a desire for less density. though the intensity of use will remain the same, that there is no change in the 8 bedrooms that it started in 1956 to 2022. Based on those conversations, though, my client is interested in reducing his request for density to 7 units. So we are no longer seeking to have this building converted from 5 to 8, but from 8 to 7. I'd also like to note that this building does not currently offer parking. There's no parking afforded by this building, and Jamal would like to add 2 parking spaces. So the variance we're requesting is from 5 to 7 with no need for a parking variance because we will provide 2 new off-street parking spots. This redevelopment is direct, and I'd like to point out this redevelopment is directly aligned with the city's master plan and Central West Choice Neighborhood Transformation Plan. Specifically, according to the city's master plan, there is a desire to expand housing choices for all residents, which this will do. He's going to create 7 market rate units with a total of 8 bedrooms, again, not increasing the intensity of use. The Central West Baltimore Choice Neighborhood Transformation Plan, which is a community-driven plan for this neighborhood where the property is located, seeks a high-quality mixed-income environment, one of the things that Jamal will provide, making this a market-rate housing. That plan also is desirous of a 10 to 15% increase in housing
Can I
value.
interrupt you for 1 second?
Yes, ma'am.
So if you're going from 8 to 7, and
Sure.
that means that you're going to drop your parking variance to 2 spaces, but you're providing 2 spaces on site, why are you here?
It's lot area.
Lot area, okay.
Yes, ma'am.
Because I didn't have lot area. All right, sorry, continue.
Okay.
So
Why are you here?
Well,
I mean, I didn't mean to say it like that, you know what I mean? But there you go.
So the neighborhood plan is seeking high-quality mixed-income environment, a 10 to 15% increase in housing values west of Utah Place, housing units that can compete in the regional marketplace, and an increase in population and number of households by 10 to 15%. It's all that local plan is also desirous of mixed unit types, a reduction of blight and vacancy, and the maintenance and preservation of the existing character. And as we are aware, it is in a CHAP district, and my client will have to comply with all of the CHAP rules. His intended renovation from this dilapidated, poorly managed unit with no parking and a bunch of peculiarities in the interior will transform into a competitive market rate apartment building with 7 units and 8 bedrooms, which is consistent. We will provide the parking. So ultimately, we were only seeking a variance of 2 units based on the lot area requirement, and there will be no increase in intensity of use. I'd like to turn it over to Jamal to introduce himself, share a little bit about his plan.
Board members, Chairman.
Yes, sir.
What an honor and pleasure to be in front of you. We're excited. My wife and I are excited. We're excited to come back into this area. I'm a native of Baltimore. Cut my teeth in that area as a junior deacon at New Metropolitan Baptist. Kind of work in that community to kind of build and expand and show good faith in that area, and that's what we're doing now. We wanted to come back to create affordable housing, apartment opportunities to the area that brought in well-to-do or thoughtful residents that are geared towards community growth, as well as professionals. Hopefully, that's the intent. I'm a business owner, have been for over 20 years. My family, we've had, we're one of the 5 largest minority owners of land in Maryland at one time, and we're excited to continue to expand and grow the community. That's what we do. I sit on the board of directors for Healthcare for All for Maryland. I sit on the board of directors for the CRA in Laurel, which is revitalizing communities. So that's what we want to do here, and my wife and I are excited to be before you. So thank you. I'm representing her. She's not here right now. She's got to take care of my 1 and 5-year-old.
Understood. Thank you.
I have a question for you.
Yes.
For both of you. Are you changing the structure of the not the inside of it, but the outside of it in any way? Are you adding additions or subtractions?
No.
Or okay.
The follow-up on that question, where are you putting the parking spaces?
Right now, the backyard is entirely enclosed, and so it will cease to be enclosed, and the rear enclosure will move 20 feet closer to the rear of the actual structure, providing for 2 parking spaces.
Okay. So that's not encroaching on anything else around there?
No.
You're just going to use the space that you have?
Yep.
Okay, thank you. Any other questions for the
No.
applicant?
Just one other point is, I think the change from 5 to 7 is closer to 25%, which is frequently within planning's parameters for variance.
Okay. All right. Remind me, Mr. French, where is planning on this, if there's any change, given the change that we've heard?
Well, the planning department's position was we were opposed to 8 units.
Yes, sir.
We will accept 6 units willingly. We will leave it to the board to determine whether 7 units is approvable.
What was the percentage that you said before?
For 6 units, it would be a 5.5% variance. We did not try to calculate the variance for 7 units, but it would be somewhere between 5.5% and 31%.
Okay,
So,
cool.
If he states 25%, that may be correct.
25? Yeah. Okay.
I was not being successful at all trying to figure that out myself.
His estimation was 25%.
It could be, yeah.
You could, sure, it could be any number between 5 and
Between 5 and 31.
Okay. Thank you. Is that for your presentation?
Yep.
Okay. Anyone for the opposition? Come on up.
I want to begin by thanking the zoning board.
State your name, please.
My name is David Nwida. Again, I thank you for the opportunity to testify this afternoon. I'm here to testify on behalf of the Bolton Hill Community Association, which has about 250 member households connected to Bolton Hill, where 1916 Utah is located. When the zoning appeal for 1916 Utah was filed, I was president of BHCA, and Amy Sheridan, who signed BHCA's letter to the zoning board regarding the appeal, became BHCA's new president earlier this month. Now in Bolton Hill, we have big row houses, and we know that they're attractive to developers to cram with as many apartments as they can to make as much rental income as possible. We also have enough experience with what happens when too many apartments are created in a row. There's invariably more parking congestion on the streets, and that's particularly the case around this block, excessive noise surrounding the building's occupants and their neighbors, and trash and recycling collection problems. In the case of 1916 Utah, we think it's wonderful that the owner wants to fix up the property and make it more attractive to prospective renters. But a variance for 8, apparently now 7, dwelling units above the 5 units allowed by its zoning classification lot size is outside the intended purpose for a zoning variance. The property is no different in size compared to other houses in its row, and after reaching out to surrounding neighbors, we have heard from none who approve of the increase in density, as they recognize the detrimental effects that added density would bring to their block. The zoning code is designed to right-size the amount of floor and lot space for the residents of a property, as well as the surrounding residents on its block. Therefore, the Bolton Hill Community Association asks that the zoning board keep 1916 Utah at its zoned 5 dwelling units according to the lot size of its zoning classification and reject the appeal to add more units. Thank you.
Thank you, sir.
Now,
Any questions?
initially, were you opposing the 8 units? That they
The
asked for?
appeal was made with 8 units, and really our position is just to maintain it as its zoned allowance of 5 units. That's our position.
So if it was 6, even though planning would say that was within its approvability, or it would agree with that, that's still too many for your organization.
Still too many, correct.
Okay. Very well. Thank you. Mr. Cagnola?
Yeah, to address some of the concerns that David brought up, so one, the Bolton Hill Community Association has a blanket policy broadly applied to all properties in the area, and is not accounting for the uniqueness and peculiarities of this particular property. And while the record has 5 existing units, the last time that this particular property was in front of the board, it was granted for 6 units with the 8 bedrooms. And for whatever reason, previous owners have allowed a 6th unit that exists in this property to be unused or unused in a licensed fashion, which we intend to rectify. I'd also like to make sure that we recognize that there is no increase in intensity. The number of bedrooms will stay absolutely the same. Right now, this building is not affording any parking at all, and currently has 5 units, and it had some sort of other thing happening with the 6th unit, and we're going to provide 2 parking spots. We are going to take cars off the street, right? This building has 8 bedrooms, which it has had for the last 60, 70 years, and now we're going to provide parking. We're going to get 2 of those cars off the street associated with this building. I'd also just like to maintain that this redevelopment is in alignment with the community-driven plan for the neighborhood. There's been no opposition from the Madison Park Improvement Association, which also claims these boundaries. Is there anything else that? Oh, trash and parking. So 1, the parking was addressed, and 2, on trash, there was a comment that had come up about all of the units having access to the rear through the building's interior common space because of the very legitimate concern that if you can't get to the rear, you'd have to walk all the way around the block, and then people end up leaving trash out front. My client is happy to make as a condition of use that all of the units will have access to the exterior through the interior common spaces, like no problem whatsoever.
In fact, the door's there already. So from a structural perspective, we're not making any adjustments there. You can go straight out through the common area, right through the front, straight out the back, into the back area, which is gated. And we're also going to have a third-party trash removal service to eliminate those issues. We've tried to work diligently to listen to the community to make sure that we align with them and become community partners as best as possible. So we hear the community. We wanted to reduce that number from 8 to 7 and make sure that we have a solid way for folks to take their trash out, what happened to walk around, and to reduce the parking footprint.
So you do have space in the rear for 2 parking
Yes, sir.
spaces, and I'm taking it to dumpster or whatever?
Yeah, I don't have the exact, I know the dimensions, the dimensions of the property are substantial. The backyard is large. There is plenty of room for both to add the parking, which can be a condition of the approval as well, to provide 2 parking spaces. And then there's plenty of room for trash and recycling for the residents.
Okay, thank you.
So is it your contention? Go ahead, sir.
I could show you there. This is the door straight through the common area that allows you to go straight outside and straight out to the back.
Okay.
As well as the parking spaces. Sorry, it's so small, but 2 cars can easily fit.
Thank you.
Do you want to submit that for the record?
Sure. Okay.
Is it your testimony that, given the number of bedrooms will not change based on your new proposed configuration, that there's no real change in density?
True. I mean, yeah, there'd be a reconfiguration. This property has experienced a host of reconfigurations while maintaining the same intensity of usage for the last 70 years. The market has a demand. The reconfiguration is really based on the market's demand for the shape and size of the apartments. We're desirous of the 7 units in this property, but it will not house any more people. They're and happy to make a condition that it'll be a maximum of 8 bedrooms as well, which will maintain its usage. And in the history of the records for this, there is a long history of the records saying 8 people or 8 rooms associated with each of the.
You're saying even when it was 5 apartments, some of them were 2-bedroom apartments?
Yeah.
Yes. Okay.
Okay. Any more questions?
No.
All right. Thank you for your presentation.
Appreciate it. Thank you to the board.
I think you answered my question. You're on a roll.
Me?
I'd love
I'm
to
good
have
here.
you.
Anybody want a cookie?
Okay, so we're here just for the lot area variance then, not for the parking variance.
Sure.
That's somewhere between 5 and 31.
I think that this is, once again, similar to the one we just talked about, because he's not changing, that's why I asked him if he's changing the outside of the building at all. And it's, I actually don't think there is a change in density. I'm persuaded by the argument, as judges are often said to me, that there's no change. 8 bedrooms are 8 bedrooms. And to be fair, someone could use one as like an office, but most of the time you're gonna put a bed in it.
It seems like this property is unique. It's a long-standing history.
Here, you can do this one.
Yeah. Okay. Based upon what we've heard and this property's long-standing history of having at least 8 bedrooms, 8 units, 5 to 8 units in its history, I think this property is unique compared to others in the area. Also, I do not believe that
I'll do it. Okay, so, based on the physical surroundings, there would be an unnecessary hardship if, actually, I don't, this one actually.
Practical difficulty caused by the code.
Would there be a hardship or difficulty if we kept it, well, the strict letter of the law is that it would need to be 5 units, right?
That's what it currently is.
But it has been between 5 and 8 for
Correct.
any, I guess the hardship would be that if there's only 5 units, then you have huge units that are not, that can't be market rate, which is the goal of, I mean, I might be spitballing here.
No, I see your point.
Yeah. If they could go from 8 to 7, suppose you could go from 7 to 5, but I guess it just makes it it's a different product. It's not the product that they want to offer. So if the product they want to offer is 1-bedroom apartments, then there's an unnecessary hardship in a building that has 8 bedrooms by making it have fewer than 7.
Right.
Yeah.
Yeah, so you can't comply with the minimum lot.
Right. The hardship is caused by the code. It's not created by the person, because once again, he's not even changing the main structure of the building. There's still the same amount of bedrooms as there has been. It's just who has a key to the front door of each of those bedrooms. I did not hear anything from the applicant that it was a desire to increase the value or income potential of the property. It was actually specifically to provide units that are capable to be market rate and are the size that you can do that for, like 1-bedroom apartments, and it's not just to get a ton more so they can make a ton more money. I don't think that it would be injurious to the use and enjoyment of other property in the neighborhood, because like Mr. Castiglia, I'm gonna say it wrong, like he said, he's taking cars off the street at this point. They're adding 2 parking spots. So actually, argumentatively, it would increase the enjoyment of people who would then have a place to park on the street. It is in harmony with the intent of the city code. I would say that it is, because I don't think that there is because it's, once again, I go to the number of bedrooms, it's the same amount of people, so it's not changing anything that has anything to do with the code. There's no evidence that it's not in harmony with the urban renewal plan, the city's comprehensive master plan, and the owner's testimony was that he was going to preserve the outside of it for chat purposes. And I don't think it endangers public health, safety, or welfare, given the private trash pickup, the fact that all the units can access the back to get to their trash area, and that, yeah, that's it.
That's it.
Yeah, take a vote. I'll start for the reasons stated on the record by my esteemed colleague. I'm a yes.
Did you say yes?
I'm a yes.
I'm a yes also.
I'm a yes.
Okay, do you want to put any conditions on that approval?
7 units, 2 parking spaces.
Interior access to the trash.
To the trash, and complying with all the CHAP
requirements.
thingies, yeah.
Okay.
Thank you.
It's your last chance. No, James.
Oh, no, I'm good, thank you.
Bill?
No, thank you. What we got?
Okay, let's move on to,
It's my birthday.
we've got that. We got to go to 163.
Okay.
Calling case number 2022-163. Guess it's the north side of Frederick Avenue,
Northeast corner.
northeast corner of South Athol Avenue. Carla Ryan, the appellant. All right. Can we have everybody here for the applicant and any opposition? Come on. Okay, hold on, let's call the case. So who do we have as the applicant?
You have to excuse me, I wasn't prepared for presenting.
Hold on. So I just want to be sure we've got everybody. So
Yes.
this is 2022-163. You're not Carla Ryan, you are?
Aaron Katz.
Okay, Mr. Katz.
From Culver, Mass. Rosenfeld.
Okay, and this is a request to construct a 4-story, age-restricted multifamily building that will consist of 59 units.
Correct.
All right. Let me hear from planning and staff after we swear everyone in, as has been an issue today.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
You do.
Yes.
Thank you.
Thank you. Planning Department has reviewed this application, noted that this property is currently unimproved. It's about a 2.5-acre site. It was last authorized for use as a townhouse development in 2007, but that was never constructed. The application is proposing construction of 59 units of multifamily rental housing restricted to persons at or above age 62. So this would be age-restricted housing. The department notes that the lot area variance required for the proposed number of units would be approximately 12.7%. The building proposed would have a height exceeding the maximum allowed by right, which is 35. However, the code allows the board to approve as a conditional use up to 45 feet of height for the building. The proposed structure, according to plans given to the department, would have a height of approximately 40 feet. The requirement for parking is two age-restricted units per parking space. Thus, there would need to be 30 parking spaces on site, and the plans seen by the department and approved by the Site Plan Review Committee on March 22nd of this year provide for 28 spaces. There is no provision in the site plan that was approved by this department and its other agencies providing bicycle parking, and the department would ask that the applicant reconsider not providing bicycle parking and at least provide some for those future residents who may wish to actually use a bicycle. The department recommends approval of the application subject to the condition that the proposed multifamily dwelling structure and related landscaping are completed or installed in accordance with the subdivision plan and development plan approved by the Planning Commission, which is pending. Thank you.
Thank you, Mr. French.
So there are 4 variances before the board for this. Minimum lot area variance, 65,812 square feet is required. 57,500 square feet is proposed, so it's an 8,312 square foot variance requested. I have the maximum height is 50 feet proposed. Is that 50? It's 50 feet, right? Not 40 feet? Okay. So as the code allows 35 feet, then there's that funny little provision that allows conditional use up to 45 feet. So this is an additional 5 feet over the conditional use standard that we would normally look at for height variances. So this is a straight up variance to height as to 50 feet. So it will be a 15-foot variance requested. So that would be the variance, the traditional variance standard. Off-street parking, 30 spaces required, 28 proposed, so it's a 2-space variance requested. Bicycle parking, 11 long-term spaces required, none proposed, so it's a full 11-space variance required. So for all of those, it's the traditional variance standard for all 4.
Great.
Can I ask Martin a question? Martin, what'd you have to say about bicycle parking?
The department considers it unfortunate that the plan that was presented to the department did not include any bicycle parking spaces, as it presumes that there would be nobody in the building who would ride a bicycle. And the department believes that there should be an option for at least some of the residents to ride bicycles and own them, of course, and store them in the facility or on site. And that's something that should be reconsidered by the
I only
applicant.
asked that because in our documentation it says planning recommends disapproval of the bike parking variance because the reason given is that seniors don't use bikes.
Yeah, that, Martin just said it the nice way. He said that, but he said it the nice way.
Yeah, I was going to take issue with it.
I would take issue with that, too.
So we're here for your presentation, but in light of the presentation, I'd like you to address, this is a new construction, is that correct?
Correct.
And so how do you base your arguments or requests for variance when you're designing it in the first place? And the code says what it says. So I want you to explain to us what the uniqueness is, what the undue hardship is that's caused by the code for the variances that you're seeking.
Okay.
You want me to take the height one?
Sure, sure. Let's give a quick,
Did we get everybody sworn?
yes.
Okay, go. Gotta ask, again.
A quick background on the project. We're in an R6 zone. This project is being developed by Enterprise Community Development. I'm with the civil engineer called Matt Rosenfeld. And we have Gene here as well with the architect from Quinn Evans. It's the site is on South Woodington, which is just 200 and something feet from Frederick Avenue, just north of Frederick Avenue. There's an existing Irvington Muse 1, which is on Frederick Avenue, and we're the next site over. Irvington Muse 1 having been developed by the same development team as the Enterprise Community Development. In the existing conditions, it's an undeveloped lot. So this is the second phase. I'm just running through this. This is the second phase of the development on the site. And the proposed use is a 59-unit age-restricted multifamily building with surface parking in front of the new building. If you look at the pictures over here, we can just kind of show where the site is. The first shows the location of the site, and then to kind of give a view of the site from the different vantage points from Frederick Avenue. You can see, if you look on page 4 in the bottom, you can see on the left is Irvington Muse 1, and we're up the block, which is Irvington Muse 2. The proposed building will be a four-story L-shaped building, ground level parking and entry plaza with a walking path that wraps around the building and includes benches and landscape area. There will also be a 4th floor outdoor terrace amenity area for the residents. I think we should try to just jump a little bit ahead to the variances that we're requesting for the site. So the first variance is the minimum lot area. The minimum lot area that's required. The 51 is this site allows for 51. It's the site, just to go back one moment, is a 2.6 acre lot, and we're developing 1.3 acres. So from that 1.3 acre, we're allowed 51 dwelling units, and we're requesting 59 age-restricted dwelling units for the site, for this project.
Why are you requesting 59 as opposed to 51?
And conversely, why aren't you using a little bit more of the area to make up for the amount you would need to get to 59 units?
Why are we what again?
It's the same question, but yeah.
You're using a smaller area to build more units.
A smaller area you mean the 1.3 versus 2.6?
Yeah.
So it's a long skinny lot, and we are phase 2.
You have to come up to the mic.
A little bit.
It's a long
And you
skinny
are-
lot. I'm Jean Beath, I'm with Quinn Evans, we're the architects on the project.
Okay.
And it's a long skinny lot, and they are building phase 2 and leaving a portion of it for the future development of phase 3.
Is that red line that says division line across?
Yes. And there's also some contaminated soils on the site, so we want to disturb as little as possible.
So that's why you're not using the whole of the
The whole of it.
2.6. Now, why,
Why the more units as opposed to 51 that the code would allow?
Yeah.
Name?
Winona Francis, the development manager representing Enterprise Community Development. And with developing Irvington Muse 1, which is on the adjacent lot, that building occupied within 3 months waiting list. So we anticipate the same for happening for Irvington Muse 2. And with the need for affordable housing in this area, we believe that we're trying to meet the demand here. That's the main reason.
Okay.
So you have additional units because you think there's a demand for the units?
Yes, we know that there is demand. We still have a waiting list for our first property, hence why we built the second one. We are proposing to build the second one.
What do you plan to put on the contaminated area?
The contaminated soil is either going to be paved or we're going to have a minimum soil cover of clean soil that's required to meet the soil remediation for the site.
Has that been approved by engineers?
Yes, yes. We've done an environmental study.
Environmental studies, right.
Correct.
we interrupted.
Yeah, we did, sorry.
Oh, no problem. The second variance that we're discussing is the maximum building height. It's a proposed 4-story building, will be 50 feet in height. There's more generous floor-to-ceiling height, especially in the first floor, which contributes to the overall building height. The majority of the building is set back. To explain the height, the feeling for the height, the massing, the majority of the building is set back by 80 feet from the front property line, with a small portion set back 40 feet. Within the portion of the building that's 40 feet from the property line, there is a 4th floor terrace which helps to reduce the massing of the building from South Woodington. So although it is true that it's 50 feet high, it's not 50 feet high for the entire footprint of the building. And as you get closer to the street, it's less than 50 feet height. There is a variety of residential housing types immediately surrounding the project. To the south is the Irvington Muse, which we mentioned. This is a 4-story multi-family building with 100 units right next door. To the west on Athol Road is Woodington Gardens. On the west is Woodington Gardens Apartment, which is 3-story garden-style apartments. And there are, to the east, there are several single-family detached dwellings and semi-detached dwellings, which are 2 or 3 stories tall. And if you look at the pictures, at the photos on page 3, you'll notice that some of these buildings are even though they're single-family residential, are pretty significant in height, and our site is lower down in elevation. So although our site is 4 stories and is 50 feet height proposed, but it's going to be in relation to the existing houses in the area, won't be significantly stand out significantly taller than the existing architecture in the area.
I've got a question for you. How tall is the Irvington Muse 1? Is it the same height as this building? I don't know if you said that and I just missed it. Is it also 50 feet?
Very similar design, where 9-foot floor to ceiling on the first floor, and then 8-foot. That's how we set our building height, was by the interior.
So it's you're saying your first floor is 9 feet, and then the floors 2, 3, and 4 are all 8-foot ceilings on, and that's going to be consistent in 1 and 2?
Yes, correct.
Okay.
So that's basically the description of the second variance for the maximum building height, and then the next variance is for the off-street vehicle parking, which is required 28 parking spaces, is required 30, and we're proposing 28 parking spaces in lieu of the required 30. I'm not going to go into the details on that one unless there's some specific questions. And then the fourth variance is a variance for the long-term bicycle parking requirement. Initially, we were coming in requesting 0, as opposed to the 11 spaces required. And the explanation is that in Irvington Mews, we have provided long-term bike parking spaces in the building, and they're never used. And we were considering to do the same on this one. Not to provide the long-term bike parking. We are going to be providing 4 short-term bike parking spaces, the 2 bike racks provided on site on Irvington Mews 2 on this project. We were considering for the long term not to provide any, but since there is significant pushback on that, we certainly would provide.
We could put it in the building.
How many did you have in the first one?
That part I'm not sure.
Okay.
It's a family community on the phase 1.
I understand. I was just going to say maybe whatever that was, half of it might be. I was just trying to give you a number. Is there space in the building to put long-term bike parking?
We could, for a couple bikes, we could certainly put
Sure.
in wall-mounted rack.
I have a question again with regard to the height. You mentioned you have 9-foot ceilings on the first floor?
Yeah, I'm thinking we went with 9 foot on each floor. You have 2 foot of structure, and we have the parapet roof.
Okay.
And it put us,
But again, is it identical to Irvington Mews 1?
I think it actually is an improvement on if we're going with the 9 foot. I'm sorry, I really can't remember right now. If we went with the
That's an
9 foot, it
important part
would
for
be an
us.
improvement on the other one.
Do you mean, by improvement, do you mean it's bigger or smaller?
It would be taller ceilings in phase 2 than is at phase 1.
And what's the reason for the taller ceilings in Phase 2 as opposed to?
It's a marketability kind of thing. It's a nicer feel apartment.
Could you do it the same as the other one?
Yep, we could.
Okay.
I feel like it might be. I really wish I had my drawings with me. I could check. Sorry about this.
You're talking about for Irvington Mews 1.
Yeah, and what our ceiling heights are.
You really should bring the appropriate information before the board if you want approval.
My apologies, yes.
mean,
And I
we're-
should know this. I can
It's hard to make these decisions if you don't have anything to look at.
probably.
Oh, yeah, we do have the, here's the elevations.
I can see it, but I can't read any of the numbers
Yeah, I don't know what this is.
It's amazing to me either.
or any words. It might, let me look in your other packet.
Yeah, you're not going to be able to read the number.
Let me just ask a question while I have you. Did you, for Irvington Mews 1, is there parking available there?
So as far as the parking, we did mention that in here, that there's, developers have found that this parking lot that there is a parking lot with 38 spaces which are never fully utilized. And there's a shuttle bus as well, but I don't think that they would be able to use that parking lot. I don't think that would be convenient for them. There's a.
You have something to show us on your phone?
Yeah, I'm sorry, I should have printed this if you guys.
You can show us and then email it to us, right?
I just, yeah, but I want to throw this out. Do you want to come back in 2 weeks?
Gee.
I'm sorry. Super.
It's no prejudice or anything.
It's right.
Yeah,
I mean,
it's fine.
you can come, we can reschedule this, you can come back in 2 weeks, and it might be worth sitting down and talking to
Let's
planning.
do that.
Pick up right where you left off.
Because, we can pick it right back up, and
Yeah, I mean, we want to give the due consideration, but these are the points that you're seeking approval on.
right,
And so-
and remember, the variance standard is uniqueness and hardship, right? So,
And you're building it to your specs.
right,
So you're creating whatever it is.
that you're creating.
Right, yeah. So
Okay.
yes.
Yeah, that's where I live.
All right, so we'll entertain a motion to postpone. Anybody object?
Nope.
It's a good idea.
We
Okay.
can put you on the June 6th docket, just change your sign to read June 6th if you need. Dang it, thank you. June 7th, so it would be 6/7.
Okay. Carla will look a little different, though. I'm just warning you.
Yeah, that's fair.
She
My
ended-
apologies for
We'll
that.
postpone
No,
this. Thank
it's
you,
fine.
folks.
All right, thank you.
She ended up in Vegas for the conference over there.
Yeah, there's a big old, you said what? You want to know what email address to send it to?
What are we doing with this?
Yes, if you can, I would say if you can compare this, as much information as you can give us in general to figure out why this new thing you're designing has to be this way.
We have to go to that
Yep.
next.
Mhm.
And then we do Terra Cafe.
Okay.
Yeah, and feel free to go ahead and email whatever you want to email, so we can have it at that, and we'll make sure we get it to the board ahead of time too.
Please.
I'll do that as well.
Yeah, thank you.
Here.
Unless anybody needs a break, we'll go to the next matter. 2022-165, 249 South Loudoun Avenue. Melissa Vega Nguyen.
I'm gonna save this. Is there someone in the hall that we need to go call?
I know, here we
Okay.
go. Thank
Which one, where are we?
165. One that came off consent, went to regular.
Hi
Okay.
there.
Ms. Nguyen?
Yes.
Okay, this is a request to use the premises as 3 dwelling units. 1 dwelling unit on the first, second, and third floor, is that correct?
That is correct.
Can I help you? Okay, I will. I just want to be sure we have the right parties here. So who do we have for opposition?
Ken Hicks,
Just you, ma'am?
and
All
I
right.
have some signatures and letters.
Okay, okay. We can swear the parties.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I hear from planning and staff.
Okay, Planning Department reviewed this application. The record available to the Planning Department indicates that this property was last authorized for use as a single-family semi-detached dwelling, which is a permitted use in the R6 zoning district where this property is located. However, because it is in the R6 zoning district, the zoning code does not authorize conversion of a single-family dwelling to a multifamily dwelling, and therefore the department recommends disapproval of the application because the zoning code does not authorize conversion of a single-family dwelling to a multifamily dwelling in the R6 district where this property is located. Thank you.
So again, this is a minimum lot area variance for a multifamily. So the last legal use that our staff found was from 1998, which was used as a multifamily dwelling with 3 units. However, it's had a vacant building notice on it since approximately that time, which was 1998. When prior to the passage of Transform, there was a provision in the old zoning code that said if you had a vacant building notice, your use went down to 1 dwelling unit, which is why the computer records reflect 1 dwelling unit. However, under today's code, which is what we have to apply, it is the last legal authorized use. The last legal authorized use for this property was in 1998 as 3 dwelling units. So it is not based on the records that staff found, not a conversion, but referring to the last legal authorized use as 3 dwelling units, which means that the only variance before the board is a minimum lot area variance.
Okay. All right. Ms. Nguyen?
Great. Thank you for hearing me today. So my name is Melissa. I represent the owner by way of project management and property management. The owner is Mr. Stephen Try of Try Group LLC. I have the settlement documents because the SDAT information doesn't match. This owner currently owns 2 apartment buildings, and the hope would be that this third would make another multi and another single-family home. So 13 doors, hoping to occupy 16 doors. I say this to say that we have an agreement with Mr. Try. We make recommendations on investments in Baltimore City, and that is to take vacants and turn them into desirable properties, or take distressed multi-unit buildings such as 900 Cater, which he owns, and correct the liens on the properties, the violations, the citations, and begin renovations so we can provide nice housing for Baltimore City residents. In particular to this property, I want to thank you for the explanation that I was going to bring attention to, and that's that the last legal use of this property was as a 3-dwelling unit. So from 1935 to 1997, it was occupied as a 3-unit building. In 1998, a vacant building notice was issued, and in 2015, an owner came with the same argument that there is no structural changes in the property at all. When you go in there, there are 3 BGE meters, there are 3 distinct bathrooms, 3 distinct kitchens, etc. So when you travel down Loudon Street, where this is located, it's a beautiful neighborhood. It is very well taken care of, and this is the only eyesore. I worry also about the length of time, which is now 24 years that has expired, when the assumption was that it had to be reduced to a single unit. That is not cost effective. It is structurally very challenging, financially very challenging, and forcing someone as a homeowner to purchase that or an investor does not behoove the community. That's why it's sat like this for 24 years. I also worry about the integrity of this is a semi-attached unit. There is a beautiful attachment to it, a very well taken care of, well manicured property that is sitting and sharing a roof and a basement lining and a wall structure where under vacant circumstances, this is a risk for fire, squatters, crime, etc. So our owner has a budget of $118,000 to take this 3-unit and do renovations as per code, and we are fully prepared to participate in that action. Our company has been in business since 2017, and we have done over $1 million in renovations successfully, including multi-units.
So this was last used, as we understand from the records, as a last legal use is a 3-dwelling unit.
That's
so
correct.
It's already configured for 3 units.
That's correct.
3 separate meters, all those things. All right. Anyone have any additional questions for Ms. Williams?
I don't. I just want to add something that may help the community be in agreement with this. So the variance, it's less than 25% from what is the desired square footage of the lot. But there is a neighboring unit that is basically a single structure housing 3 addresses, and they do very well. My point in that is we've taken aerial Google Earth views of the property, and from January through as early as yesterday, we performed site visits to observe the density of the community relating to parking spaces. And we were going to consider that as how dense the community is, would it suffer if we put 3 independent units in here. So we did it on Saturdays, Sundays, in working hours, outside of working hours, and did estimations that within that street alone, it would accommodate roughly 81 vehicles of parking, and never did it reach above about 40% capacity. So that was also our means to assess would it accommodate. In the rear of the yard, it would actually suit a driveway for 2 cars, and we had our architecture drawings prepared to show that that would accommodate that as well.
Okay. You're not seeking?
We are not.
Just for information purposes?
That's correct.
Okay, thank you.
Sure.
Okay, if there's nothing more for Ms. Nguyen? Ma'am?
Thank you for allowing me to speak. My name is Kim Hicks, and myself and my husband, we own the home that's adjacent to 249 South Loudon Avenue.
The attached one?
The attached one, yes.
Okay.
I do have 247. I have a letter, one from myself and my husband, and I have copies if you guys would like. And we have a list of residents in the community who oppose this being changed to a 3-story or 3-family dwelling. I'm going to read, excuse me, the letter from myself and my husband first, and then the one from our community association president. Okay, my husband and I have owned the attached dwelling at 247, and we've lived there for the past 36 years. Okay, for the past 15 to 20, and it's after hearing her say 1998, so it's been 24 years. The building has been vacant. We have endured the building being used as squatters individuals doing unlawful behaviors, as you've said, and all types of pests caused by various situations. All of those situations were manageable and capable of being resolved through the proper channels. We're writing to express our strong opposition to 2022-165, the proposed rezoning for 249 South Loudoun Avenue. We have experienced what it's like to have multifamilies living in the building, including 3 times the noise, 3 times the trash, and a lack of accountability to who maintains the property, the grass, the snow, the rodents, and the pests. And I have a picture here of the grass as it looked Friday. I did a 311 and someone did come out to cut it, and I'm sorry I ran out of ink. Someone did come out to cut it on Sunday. And that person came out, they cut the grass, and they blew all of the debris into our yard. We had the cuttings and clippings on top of a gazebo we have in the back. We had grass blown into our yard, so they weren't very considerate when they did that cutting. Let's see. Please understand that we are all for this property being renovated into a single-family dwelling. We feel this would be much more beneficial in a community where most of the homes in close proximity are the primary resident of the homeowner. In 2020, my husband and myself, we even made an attempt to purchase this property through one house at a time through a auction by A.J. Billick. We were unsuccessful because it went for what we thought was an unreasonable amount of money. Since then, that house has been auctioned off at least 4 times, and it's been forfeited. The auction was forfeited because we told them that we're going to oppose a three-family dwelling because we feel the community would benefit better of having just a single-family dwelling. I say, please understand. I see my husband and I, we look forward to this building being renovated, which would truly bring an end to many issues we have endured because of the neglect of the property. Please understand our concerns as lifetime Baltimore City residents, active community workers, and taxpayers. Your help in this matter is greatly appreciated. Okay, I have a list. I have 2 pages of signatures, and these are just the homeowners in the 200 block of South Loudoun Avenue.
Okay, let me just raise an issue.
Mhm.
We've heard from from staff that the lawful use of this property is just 3 units.
We understand.
So what's not before us is a conversion to 3 units from a single family. I understand that's a desire of you as the immediate adjacent neighbor, but the issue of whether it's 3 units or a single family is really not before the board. The issue is the minimum lot area variance and, but again, not the issue that you appear to be supporting here, which is single family with all these signatures. I take it that's the basis of those signatures?
Right. We're opposing what the hearing says, as to use this as a multifamily dwelling. If I recall correctly, I don't have all of the words. Yes, it says it's to be used as a multifamily. So we're opposing that.
Okay. And all I'm raising is, there was a question as whether or not this was a conversion from single family to 3 dwelling units.
Right.
And the fact that nobody's been in there for a little while is a different issue than whether or not it's lawfully 3 units and can be used as 3 units.
Mhm.
So.
And it was our understanding that because it has gone without 3 families in there, without being used as a multifamily, that it lost its zoning.
Well, what was explained here, and you can state it again if you like.
Yeah.
It did under the old code. So prior to 2017, so there was testimony that someone in 2015, I think, tried to take it from 1 to 3. That was the case then. But that provision of the code no longer exists, so we have to look at the last legal authorized use.
Okay. So my time spent here today, are you saying was for naught?
Well, in opposition, you're raising the issue is we want a single family. And what I'm telling you is the law states that it's a 3 dwelling unit property. And that is not what's before the board to not allow a 3 unit property. The issue is minimum lot area variance in terms of the size of those particular units.
I hear what you're saying, and it just, to me, it just it doesn't agree with what the zoning sign says.
It's probably, the sign probably did say.
Yeah, I'm sure.
Yes.
And what, just so you know, what takes place is based on the best information that everybody has. When the application is filed, there are a number of things that take place, including research, staff does here, to confirm, what is the last lawful use and what does the code require us to look at. As Ms. Byrne mentioned, the last version of the code would have likely precluded, or at least required, that precluded such a conversion. But here, we have to go back to the last lawful use, and on the records available to us, that is a 3-dwelling unit.
Okay, so in actuality, there's nothing that we can do to oppose this being used as a multifamily dwelling.
I mean, we have our standards to apply, but with regard to making it or enforcing a single family, my answer to that would be no.
Okay.
Yeah, there's nothing.
If the only issue before the board, so it could not be used as 3 dwelling units if the board denied the variance request, and the variance request is to lot area. So
the variance request
just like
defaults
you heard
back to
the one
yes.
before where it was lot area and parking.
Yes.
So it's they're wrapped together, but it's.
Yep. I understand. It's just unfortunate that this is a beautiful home. I just can't see. I've lived there 35 years, and it's been 3 families in there multiple times. I just don't see it being a good investment. That's all. I mean,
Has it ever been 3 families before with this particular owner?
no. This is a new owner. The first new owner in 5-8 years or so.
Sure.
Yeah.
And it'll be the first time it's been occupied since I graduated from high school, since 1998?
Yes, since my daughter graduated from high school,
Yeah.
yes. And, I'm not going to prolong everybody else's day. I've been here long enough. If it's nothing that I can do about this, I'm just very disappointed. I
just wanted to raise that technical issue that's before us in light of what your opposition is.
And I just think in the future, when signs are posted like that, it should be very clear that if someone can't come down and oppose what's on that sign, I mean, I've spent all day here. And, I don't want to say it was a waste of my time because I learned a lot. And I pray that whoever your investor is, I pray that I get to meet them, and I pray that they're serious about making Irvington, continuing to keep Irvington a good place. It's a wonderful neighborhood, like you said. My husband and I, we keep our property, we keep it up, we keep it safe. I mean, there's been many times we've cut the grass, we've mowed the lawn, we've put rat traps down, we've done a lot to just keep our property up to date. And I just pray that whoever bought this property, I hope that they have a heart for Irvington and a heart for Baltimore City, and they're not just here to throw a bunch of people in that building and just make a lot of money.
Understood. You'll be happy, I'm sure.
I hope so.
Thank you.
Thank you.
Ms. Nguyen, anything else?
I just want to provide to you the photos of the aerial views of the parking, and that basically is enforcing the idea that as far as density is concerned, it would allow for it if you're at least looking at parking standards. And I also want to just show you that this is a multi zoning area, and that is to say that I'll show you an aerial view also, that there is R6, R7, C1, C2, so this is not a condensed neighborhood. And also the last to say that, Ms. Davis? Ms. Hicks, I'm sure your property value and the property values around there have suffered because of this property, and they will surely increase in value when it is no longer a vacant property. This just shows that there is a lot of space in and around that area.
You're submitting all these for the record?
Yes, please.
Okay. Do you want your Post-its back?
I do not need any of those.
Okay.
That would be all. Thank you so much.
Thank you for your presentation.
I'm sorry you had to.
Sure.
There you go.
And there's a couple pages in there you can flip through.
Serena, you feeling lucky?
I'm feeling lucky. 3rd time's a charm.
Thank you so much.
Yeah, this one is. Thank you.
I lost my cheat sheet. Oh, no, I found it. Are the conditions on which the application is based unique to the property?
Can I just make one more statement?
Yeah.
That these, I'm getting that.
It's okay, put it on the record.
These pictures were taken, many people in that neighborhood, we work, and all of those pictures were taken during times when most people are at work. That if everyone's home in that neighborhood, there are many more parking spots taken up, because there are multiple cars in each household.
Thank you so much, ma'am.
Thank you.
If you're accepting additional testimony, if you just look on that parking page.
You've provided testimony of a parking study, basically.
Thank you.
And
Yes, thank
we
you.
consider that.
Okay, it is the lot area variance is unique to this property. Generally not applicable to other property within the same zoning classification. It's unique because the house is already built and it's already there, and it will be an unnecessary hardship or practical difficulty to alter the density of the house because, once again, it's already built, it's already in a structure. And in fact, there are already 3 units in there, but it says reasonable, yeah, they wouldn't be able to make, anyways. The unnecessarily hardship is again caused by the code because of the lot area requirement. It has not been created by any intentional action of anybody. They just bought the house as it was and have not changed any of the structures. It is not based exclusively on a desire to increase the value or income potential of the property. It's just to, I don't know, use it as it is intended to use and as it's been used. The variance will not be injurious to the use and enjoyment of the other property in the vicinity, when in fact, from everything actually that Ms. Hicks was talking about, it may make it better, and that there will be someone there to mow the lawn and keep the trash out and not make the structures, and to keep the structures up. The variance is in harmony with the purpose and intent of the city code. For that, there's no evidence of any urban renewal plan, and there's no evidence that it's against the city's comprehensive master plan or any CHAP-related issues. And the variance will not be detrimental to public health, safety, or welfare. There's no evidence of that. And it won't be contrary to public interest, in that I would say that the main public interest is that the property not be vacant, and this is actually doing that.
Okay. For all those reasons, I'm a yes.
I'm a yes.
I'm a yes.
I'm a yes.
Before we get to the last one, can we take a quick bathroom break?
Yes, sir. Yes.
All right.
Please and thank you.
How quick?
All right, so we're off the record for 5 minutes, and we'll get started.
All
All right, is everybody ready? Okay, we're back on the record.
Yeah, eat the cookie.
Okay. Calling the case of calling case number 2021-217, 101 through 103 East 25th Street, New Terra Cafe LLC.
Yes,
Can I have all the parties who intend to testify?
most of them left, but we got a few
That's all
left.
right, I'm just asking, so.
Okay.
Raise your hand to be sworn.
Raise your hand, anybody's gonna testify. If you haven't signed up, you might be able to sign up also.
Okay, I'm gonna need you all to stand because you're all gonna have to be sworn. Right hand?
You swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, this is a request to add live entertainment to the existing restaurant use to include the outside of premises in the rear. Is it correct?
That's correct, Mr. Chair.
Good afternoon, Mr. Shield. Good to see you, sir.
Nice seeing you too. It's been a while.
You state your name, please.
It's live entertainment to the outside.
He said that.
That's what I said.
I'm gonna be the lawyer today. Okay?
Oh, yeah, you
Okay.
want to call into us.
And we're gonna have, hold on. I'm going to have one person speak at a time. I know, Mr. Shield, I'll trust you to keep that.
Yes, Mr. Chair. My name is Robert Fulton DeShield. I represent the owner of the Terra Cafe. Terrence Dixon standing to my immediate right, and we have a number of people here who may or may not all testify, but they're here and they've been sworn.
Very well, sir.
Thank you.
The folks we have for opposition, if any? None? All right. Hear from planning and staff?
Planning Department reviewed this application, notes that this property is located in the Charles 25th Urban Renewal Plan area, and for the record, notes that there is nothing in the Urban Renewal Plan that would prohibit or further restrict this proposed use. However, the department also reviewed the history of this property in regards to this proposed use. The board approved live entertainment in 2011, and it approved outdoor table service also in 2011 on a separate appeal. The approval explicitly limited the outdoor seating to the sidewalk along 25th Street and conditioned approval on having no outdoor bar or live entertainment on the exterior of the premises. The application that's before you today proposes to use the entire width of the paved rear courtyard behind the building on this property as both an outdoor seating area with as many as 24 top tables and seating, and a dance floor and performer stage where amplified musical acts and other live entertainers would perform. The site plan that was included with the application for this rear area of the property does not include an accommodation for deliveries to the restaurant, nor for removal of garbage and trash from the restaurant or from the multifamily dwelling that is above the restaurant, this being a 3-story building. It also would appear to remove off-street parking now used by some or all of the various uses of this property that are currently authorized. Therefore, the department notes that approval of this application may also require approval of a variance for off-street parking regulations due to reduction of off-street parking provided on site. The department is concerned specifically about the concept of having outdoor live entertainment at this location. This particular property is configured in such a way in relation to a neighboring property that the sound of outdoor entertainment would be channeled primarily in a southward direction towards a primarily residential area. This property is located on the south side of East 25th Street, and the sound would be carried primarily towards the Old Goucher community further south. The department is recommending disapproval of the portion of this application relating to expanding live entertainment use to the exterior of the restaurant structure, but it has no comment on the remainder of the application. Should the board grant approval of this application in its original form or as it may be amended by the applicant, the department would recommend that approval be subject to these conditions, in addition to whatever conditions the board may establish. A copy of the use and occupancy permit for the premises must be kept on the premises and available for inspection by representatives of Baltimore City at all times. A copy of the written approval by the board of the live entertainment provided on the premises, including details of any restrictions or limitations on live entertainment provided, must be kept on the premises and available for inspection by representatives of Baltimore City at all times. And a copy of all other permits and licenses required pursuant to the written approval of the board must be kept on the premises and available for inspection by representatives of Baltimore City at all times. Thank you.
Thank you, Mr. French.
Projects is to add live entertainment to the existing restaurant, inside and outside, including outside of the building in the rear yard. So what's before the board is a conditional use live entertainment. If the board recalls, this case was previously on the November 30th docket, November 30th, 2021. There was significant neighborhood opposition at the time. The applicant was encouraged to meet and work things out with the opponents. We have one letter in the file of opposition from Charles Village Association. Over the last several days, we've received several letters of support for this particular use, and as the applicant stated, there were several people here, and we have people on the sign-in sheet who have identified their support for his application as well, which will be made part of the record.
Very well, thank you.
If the chair or staff would refresh my memory, I think we ended asking that the developer, the owner, try to develop an MOU with the community associations.
Yeah,
That's
the-
one. And two, are we only hearing new information?
So there was significant testimony the last time from the opposition, yes. So I think it had come back around for additional support. I think we were back to the second portion, right? So we were back to the applicant to rebut the opposition and to present additional information. And I do have in my notes that he was encouraged to meet and work things out with the opponents, which he agreed to do.
I think we specifically asked for that.
We did.
I know I did, anyway.
Yeah.
Okay. All right, Mr. DeShiel, that in mind?
Good afternoon. Good afternoon, Mr. Chair, members of the board. For your consideration is a request for expansion of live entertainment from the building to the area which is now referred to as the Jerk Garden, which at the time of the original approval of live entertainment was not paved at all, and has been expanded. And I don't know if you've seen it. I don't know if you've seen the pictures of it, but it will be. It's an oasis in the middle of it looks like an oasis in the middle of a desert. Quite frankly, it's been substantially improved. And the reason for that improvement is, the real question is, where lies the public interest? And of course, the public interest changes over time. The most recent event that caused the change was, of course, COVID. As a result of this structure, by the way, houses not just the restaurant and the Jerk Garden, but it also houses a number of residential units. So, and some one or two even office units within the same building. COVID caused a change, an unanticipated change in everybody's way of doing business. And particularly hard hit by COVID was businesses such as my clients, the so-called hospitality industry. To some extent, it was assisted by the PPP program, but having money to pay employees didn't do much good if you had no customers. And the customer base has been significantly reduced over time, to the point where even maintaining an establishment of this time without maximizing the total use would constitute a considerable hardship. Live entertainment, Baltimore City has a noise ordinance. So we're not dealing with a situation where the volume of sound is unregulated. The city has a time of day noise ordinance, and it applies to all sound, whether it's coming from a DJ or jackhammers. And our client would, just like every other business, would be obligated and bound by that and would comply with all of those requirements. With respect to the loss of parking, I don't believe that was ever really used for parking anyway. It wasn't suitable. The area really it was overgrown, and the pavement was not as it is today. It was blacktop. Now it's completely redone with concrete. And as I say, it's an oasis in the middle of looks like oasis in the middle of a desert. I think I would urge the board to consider the fact that of the hardship that's caused by COVID, and the fact that the expansion of live entertainment to the outside would be regulated by both time and sound under current city ordinances. It's consistent with the uses of the area. It would enhance the area. It provides an opportunity, venue for people to enjoy a kind of entertainment that is not otherwise available, hardly in the city at all, particularly in that area. And we think that it would be in total harmony with the community. And we did meet, by the way, Councilman Cunningham. I wasn't present, but my understanding from my client is that the meeting was cordial, and I think the letter that came in really didn't have anything to do with zoning. It raised more issues with the liquor board, which aren't before you. But at a cordial meeting, there was no agreement to anything other than the fact that we would operate in accordance with applicable laws. And that's really all I have to say. Thank you.
Okay, do you know when that meeting was, Mr. DeShiel?
May
Meeting was
May 16th?
May 16th, okay? Came in.
That was the only question. Wait for the next question.
Okay.
I'm sorry, yes, sir.
Excuse me?
Terrence Dixon.
My name is Terrence Dixon. Dickson, 1 R, please, Terence. Thank you.
And I would add this, with respect to the conditions that planning impose, I mean, so far as I understood, there's applicable law. We have to comply with those anyway, so we wouldn't have any objection to compliance with all the applicable laws.
Okay. Who are we going to hear from next?
We will hear from the owner, Mr. Dixon.
Floor yours, sir.
Hey, good evening, good afternoon.
You want to add anything to what I said?
Yeah. You know, we had a great meeting on the 16th. They came in, and of all the board of Charles Village zoning, all right, 2 people showed up, okay, that had real concern in reference to what was going on. After having dialogue with them for over an hour and a half, okay, one thing that was very apparent when they first walked into the church garden, they'd never been there. So they've been fighting against something they haven't seen, and they was mesmerized. I asked them, we had a discussion, they loved the place, the energy, the whole 9 yards. On a scale from 1 to 10, they rated this place 9 of where they would want to be in Baltimore. They confirmed that the place was well taken care of, it was clean, and it was in compliance, there was no flaw.
Sir, do you know who showed up to your meeting?
Yes.
We need your phone.
No, Miss Tiffany. All right. All right, my partner who was here with everything, they're gone. I had 20, 30 people here. What is her name? Susan. I apologize, I do not know her name off. I can describe her, all right? And you know who she is. You've spoken with her before when we were on the line. What is her name?
Well, I don't
All right.
I'm not gonna.
Whoever has that information, possibly. But,
Yeah.
Go ahead, sir, continue.
Yeah, all right. At the end, during this meeting, we had a great discussion. We talked about the previous. Understand that this is not a new relationship. This is a relationship of over 20 years. I've been on the Charles Village Benefit District Board and really spearheaded in reference to having a business, the cooperation of business in the community, all right? And y'all got me so heat, okay. Business in the community. She agreed at that point that she would support us. Both of the people at that point shook hands. We have videotape. We taped it because we wanted to share it with others. All right, we know that because of COVID, everybody isn't real friendly with coming out, but we wanted to keep the community abreast of what was going on.
Okay.
At that,
I'm sorry.
Yes.
You taped the meeting, you said?
yeah,
Do you plan to submit that tape to the board?
I would like to commit it, and we didn't know how to. It was one of the conversations I have, and I mean, I have it dissected to the point that we will talk about the people that came in. It will show in reference to where she gave a commitment, shook hand, and said she was with it, and also the person that was with her.
What format do you have it in now?
I have it in text. I can send it to you.
No, I thought you said you had a video.
I got the video.
I'm saying.
You have on your phone? I sent it to you.
You sent it to me.
Yes. Can I use your phone?
No.
If there's something that you want the board to consider and you think it's relevant,
It's relevant. It's very relevant.
then you'll need to submit that so that we can have an opportunity to review it and consider it, okay?
I will submit it then, okay?
so you can-
Because at that point, she committed and said that she would be supporting us. And then at the 12th hour last night, I received a letter stating that everything was fine except for the last part, and where she said they all voted against me. But also, they haven't had a meeting because it's a public, and they did not have a meeting, all
Okay.
right?
This letter, hold on. Go ahead.
So do you, so you have something, it's just not here?
Or
Excuse me one second, I'll get my phone.
I believe it exists in the digital world.
it exists in the digital world. All right.
And I think it's a video of the meeting.
Sparks is her name.
Okay, let me just say that if there's any information that you want us to consider, we're gonna have to have that information to then be able to review it and look at it, whether it's a video, the letter that you mentioned that you got, at the 12th hour, you got a letter stating various things. Has that been submitted to the board?
I think that's the letter that.
She's already, that was the one opposition letter. I got a question for you. How many letters did you get on the other side?
No.
We're not there yet. Let's,
So
you present
the
your.
one that I talked about was the one that we got before. So I haven't, I'll look really quickly in the email. Was the original Charles Village opposition was the one I was referring to before that we got before the November 30th hearing.
No,
So if there's more. All right, so hold on, I'm looking in the email now. to see if
Okay.
we can find it. All right, so we have a letter from
Okay.
the Charles Village Association, came in Monday at 10:10. Dear Ms. Byrne, Charles Village Association Board has voted decisively not to support the owner of Terrence Dixon's application to add live entertainment and outdoor dining to the well-maintained outdoor space at the rear of the new Terra Cafe Street at this time. At the community input meeting, May 16th, between 5 and 6 on site, Mr. Dixon committed to hours of operation that vary daily from 9 a.m. to 2 a.m. with live entertainment ending by 1:30 a.m. He promised to adhere to the city noise ordinance.
Right.
Mr. Dixon has not agreed to negotiate a community operation management agreement with the Charles Village Association. CVCA maintains over 20 signed community agreements with liquor establishments throughout Greater Charles Village for new renewal transfer liquor licenses. Routinely, CVCA presents the individually negotiated and signed community agreements at the respective liquor board hearing. Community looks forward to working with Mr. Dixon.
Yeah, see, that's what I was.
Came in on Monday at 10:10.
Right, that's the letter I was referring to that I think refers to at a time for renewal of the liquor license or something, which has nothing to do with this. I've never seen this agreement that they're talking about having been proposed, but as I read the letter, it all related to the renewal of a liquor license, which was not an issue, so we didn't.
I think what they were talking about is normally the CVCA negotiates with people who own bars and restaurants
Right.
and creates these agreements. And then when it's necessary, they present them in front of the liquor board, probably in front of the zoning board at some point. I think they were just saying that this isn't like a new thing we're creating for Mr. Dixon and Terra Cafe. This is something that we do regularly, and we use these agreements as evidence to prove at liquor board that the community is in agreement with this institution. I think that's the
Okay.
only reason they brought that up.
Okay, well, that's fine. I wasn't at the meeting, and I don't know that they proposed any hours of operation with respect to live entertainment different than those that my client had indicated. And as the letter indicated, what he proposed was to have live entertainment consistent with the normal hours of operation. I think that's what the letter indicates. And so far as I know, I don't know that there was a counter proposal made at the meeting.
Mr. Dixon, to your understanding, what is it that the CVCA wanted you to, because what they've written is that, that you agreed not to negotiate a community agreement. What, to your understanding, what is it that they wanted you to commit to that you didn't want to commit to?
They wanted me to sign an MOU.
Right, that,
Okay.
That said what?
They wouldn't even share what it would be.
well, that's impossible. You well, no,
I asked them to email it to me, all right? What they wanted was a commitment that I would sign whatever MOU, and we have history.
Listen,
No.
hold a second.
Yes, sir.
There was no proposal made that I'm aware of for anything different with respect to operating hours.
Well, no,
And-
there are things other than operating hours.
but
I'm wondering what the terms are that, to my understanding, the reason you didn't come to an agreement is there's something that they wanted you to either do or not do that you were not willing to do or unwilling to not do, whatever. But there was some point of disagreement between you, and I'm trying to understand the nature of your disagreement with the CVCA.
Madam, let me answer, please. Board Member Turner, if there were terms that the Charles Village Association wanted, they have never disclosed what those terms are to my client or to me, and they did not put them in the letter that was just referenced.
So my follow-up question is then, what did you do for an hour at this meeting? What did you guys do for an hour at this meeting then, if you weren't talking about how you could create an understanding?
What we did, we talked about what was happening, what with the garden.
Okay.
We talked about live entertainment, and Sandy spoke for about 40 hours of why I should sign this MOU that she would not have, that she wouldn't show us. All right, at that point, that was about the best conversation.
That feels wrong to me. That feels like a thing that can't actually happen.
So are you saying it was unilateral, like their terms or no terms? Are you asserting that they
No, board member.
signed an MOU?
Who's your
I
question
can't
addressed
hear
to?
you.
Mr. Dixon, are you asserting that they asked you to sign the MOU that essentially was there was no negotiation? Either sign the MOU that they proposed to you, or there will be no agreement
I'm
between
not
you two.
understanding, and I.
Did they give you a piece of paper called an MOU?
No, they did not give me an MOU.
Okay, answer the question.
No,
Did they
yes.
did they tell you any terms that they wanted in the MOU?
No, they did not.
So to our
Okay.
understanding, they said, we're gonna give you a piece of paper for you to sign that has some terms on it, and you were like, what are the terms? And they're like, we're not gonna tell you, you just gotta sign it.
The question, what she kept saying was that, I want you to sign my MOU.
Well, hold on a second. Was anybody else here who was present at the meeting?
Tiffany, right here, she's back.
Oh, come up, please.
Hold on. One at a time. If anybody else is going to testify, we'll bring you up one at a time, but nothing from the gallery.
Right.
So, and we're going to address because Mr. Dixon is speaking based on his in-person attendance at the meeting.
Right.
Right.
So let's just leave it to that, Mr. DeShiel, with respect.
He was
We're
there.
gonna address the question to Mr. Dixon, let him respond, and then we will keep moving.
And the reason that we're doing this is because part of why we postponed the last time was so that you and the community could come to an agreement. And we're trying to figure out what happened, why there was no agreement if you sat for an hour in the beautiful dirt garden and didn't talk about.
We got stuck there because she wanted us to sign, but she did not want to share anything of what we were going to sign. It was like she wanted a commitment, I'm going to sign, and then she would show it to me. We asked her if she could email it to us so we could read over it, okay? All right, still nothing, all right? And at that point at the meeting, she shared with her and the other party that was with her from the board, said that they were going to support us.
Okay,
Okay.
thank you. In response to that, you mentioned earlier that you recorded the meeting,
Yes,
okay? Did they understand, the other people, they understand they were being recorded at the meeting?
yes, because they spoke into the camera also.
Okay, and have you located a copy of that recording?
I'm trying to locate it in the phone now.
So do you mind if we ask her questions?
No,
The woman
not at
who's
all.
standing in the back while he finds that recording, maybe?
Just come up and state your name if you would.
Good afternoon, my name is Tiffany Page.
And you?
Good afternoon, Ms. Page.
Good afternoon.
State,
Do I need to be
state.
sworn or anything?
Yes, thank you.
I thought
Were you here
I thought
when
you already did
I was
that.
here, I've been here all day, I just stepped
Did you
off for a
stand and
moment.
raise your hand?
I did not, no, not doing
Okay,
that.
then
Okay, all right, do it.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I did.
Thank you.
And what is your connection with the Terra Lounge, if any? The Terra Cafe, I'm sorry.
I work closely with Mr. Dixon with the Terra Cafe and Terra Loft Consulting.
Let me stop you for 1 second.
Sure.
Can you work on finding that video, Mr. Dixon?
Yeah, you find it while
Yeah.
you talk.
Okay.
Wherever you need to find it, please.
Okay.
Do you mind if I?
No.
Ms. Page, were you at that meeting on May the 16th?
I was.
Please tell us what happened.
During that particular meeting, Miss Sandy and Mr. Bryan attended. During that particular meeting, they came in. Mr. Bryan and both Miss Sandy assured Mr. Dixon that he would receive support from the Civic Association, from CVCA, and towards the conclusion of the meeting, Miss Sandy brought up her MOU. The MOU that she wanted signed, and I specifically asked what was in the document. That's how I know the document wasn't presented, because I specifically asked. And it's recorded on the video, me asking what was in the document, what did the document consist of.
Did there come a time prior to this meeting that any of these individuals expressed to you all what they wanted?
Not to me specifically, no, sir.
Okay, I'll address it to Mr.
Never.
Dixon.
That was the first time I spoke to Sandy or anybody on that committee since the point when we had the virtual hearing.
Okay, and
No,
so,
they never reached out or anything else of that nature.
all right, and so, with regard to a statement by Ms. Sandy or anyone else saying, I want you to sign my MOU or our MOU, could you say what's in it?
Yes.
And what was the response that you received?
A simple agreement.
Not, these are
Quote,
the terms.
unquote.
That's it.
Not, this is what we like, not,
No.
we would like the time of the, if any, live entertainment to cut off at X.
What would the agreement be then? Why do you need agreement if?
That was our question as well,
was the
sir.
question.
So you wanted to like review agreement and negotiate it, and there was no room for negotiation?
There was nothing to
Correct.
negotiate.
Okay.
You gave explicit instructions. You shared with them to go back, you shared with us to go back and work it out. The way that you work out a deal is you put it on the table and you go over it, okay? That's how you
I'm
work
just
it out.
saying,
It was
what-
it was
what
never
you-
put on the table.
What you're describing now is not the way I know the Charles Village Association works. So what you're describing now is not the way the Charles Village Association normally works.
Yes.
And I think I'd like to see this video and,
Oh, I
you
certainly
know,
would.
I haven't seen it. They haven't given it.
No,
No, what he's talking about, with respect, Mr. Cunningham, I don't,
Are they trying to say that? That's how it reads, right?
I have no idea how Charles Village normally works. I mean, you know, when Charles Village was formed in 1945, there wasn't even public accommodation, so I don't even know how they work. But,
Mr. Shields, let me ask
yes.
you, were you involved at all with negotiations with Charles Village? Or any of the community associations?
I was not present at the meeting, but I encouraged my client to proceed. And in fact, it was my idea that from the last hearing that he proceeded. And
And my question to you, Mr. DeShields.
I was not there.
Okay, I know, understand you were not at the meeting.
Right.
Had you had other communications with any members or representatives of the Charles Village
I have not.
Community Association?
I have not.
Okay, thank you.
There's something missing from this letter. Do you know who Miller Roberts III is?
Who?
Miller Roberts III?
Miller?
Roberts III.
He's the president of the
Was he at the meeting?
No, nobody.
individuals
There was only 2 individuals that came to the meeting.
Okay.
So just for clarity, Ms. Sparks emailed the letter to me.
Yes.
But the letter was signed by Miller Roberts, the president of the association.
And I do see Sandy Sparks and Brian Beverly listed as board members
Right.
on their letterhead at the bottom.
Right, and as you indicate, the letter was signed by someone who wasn't present at the meeting. There's no specificity, there's no indication in the letter that there were any terms offered to my client at all.
This won't even stay up.
The last sentence of the, I think, Mr. Shelton, to your point, it's the last sentence of the middle paragraph says, routinely, CVCA presents the individually negotiated and signed community agreements at the respective liquor board hearing. So
That's
she,
not stock.
no, so it's,
They're saying their practice.
know what
is
happened
individual-
here.
Oh, yeah, what happened? Yeah, they say their practice is to individually negotiate. You guys say you were there for negotiation, but were told, take it or leave it. Is that not what's happening here?
That sounds like what happened to me.
Yeah, but the take it or
what's-
leave it, what I'm hearing in terms of testimony is there was nothing.
Right, there was nothing to take.
It being
It was
an
like,
agreement.
it's signed and
Right.
everything, but I'm not gonna tell you what you're gonna sign, I'm not gonna tell you what's in it, I'm not gonna negotiate, either you're gonna sign my MOU, or we're not gonna approve you, and that was her attitude at the beginning, but then after the end, she said that she would support us.
Didn't you say previously that at the beginning of the meeting, they said they were going to support the proposal?
Excuse me?
At the beginning of the meeting, so you originally said at the beginning of the meeting, what Sandy and Brian told you was that there was their goal to support this.
They were gonna support us.
And then by the end of the meeting, they were like, in order to get our support, all you have to do is sign this thing we're not gonna let you look at. We're just gonna give you a back page with a signature line on it.
We asked if they could email it over to us.
Sure.
Madam.
Ms. Turner.
Ms. Turner, I'm sorry.
It's okay.
I apologize, first of all, I'm in considerable pain here, and we've been waiting here for a long time. But, the fact is, if Charles Village Community Association has something to say, they ought to be here to say it. I mean, I had to wait here. I had to wait here with a hurting back, with a dislocated disc, and hardly walking, and you're standing here defending somebody who didn't even show up. That's.
We're asking questions.
Mr. DeShiel.
I apologize. I apologize, but I'm just a little offended by what's going on.
You certainly have every right to be.
Okay.
However, we got to make a record. And so
Okay.
if you're here, we want to hear what you have to say.
I appreciate it.
And
None of us were at that meeting.
we weren't at the meeting.
And I wasn't there either.
And so
Which
we
is
have
why we're trying
challenge
to
and
make it clear.
We have to ask questions so
Okay.
we can get a better understanding of what's taking place.
Okay.
This is not the only portion of the record. We have obviously a whole set of testimony that you were responding to and coming in. So we're trying to ferret that out.
And I apologize for losing my temper, Mr. Chair, but the fact is that the most recent correspondence from Charles Village doesn't say anything about this proceeding. It only talks about a record or an agreement that they normally present before a liquor board proceeding. And it's signed by somebody who, like me, was not even at the meeting. And they've never described to you or to us what the proposal that they wanted. We can't make it up. I mean, it's like shadow boxing.
I understand. And what we also now know is you've indicated that you have a video of this meeting that we're all making reference to, right? That we weren't there and a number of other folks weren't there. So we would like to review that and consider that in connection with what's before the board. So if you have any means to provide that information or anything else, you really need to submit it and make it a part of the record so that we could consider it.
Mr. Chair, I would request that the record remain open to allow my client to find the video and submit, which we will do and promptly. I didn't know there was one until, but we would do promptly. There's no reason why you wouldn't have it by tomorrow.
Now that we know there is one.
Yeah.
We certainly, it's relevant, right?
Yeah,
Very
of
relevant.
course it is.
100% sure.
Okay.
That's something that we ought to be able to look at and assess.
All right. In the interest of, thank you, Mr. Chair. In the interest of time, I simply request that the record remain open to allow us to submit that video, which I think will confirm the testimony of the people who were actually at the meeting. And again, there are several people here. I believe their testimony would be cumulative, and so we don't want to take more time. They're all here to say they support the Terra Cafe and the Jerk Lounge. If there's anybody here say otherwise, stand up and leave the room. but I think they would all say that, and I think unless there's someone here in particular that you really want to have, Mr. Dixon, is there someone here that you really want to have speak?
Huh?
Is there someone here that you really want to have speak? Otherwise,
I want to have her speak because she took her time away from her desk.
I don't know who she is. Who she is? Okay.
All right.
Come up, please.
Not up, Clay. All right.
I'm going to have to leave.
Please do.
Okay.
All right, we'll make sure.
Introduce yourself.
Hold on.
Can I just,
Ms. Byrne, go
before,
ahead.
I apologize, but before you get started, I just want to confirm what's in your application as far as hours of operation. So what I had in the application was that live entertainment would occur from the opening times until 11 p.m. Monday through Thursdays, and until midnight Fridays and Saturdays, and until 10 p.m. on Sunday. That was what was in your application. Is that what you're asking for?
Well, I'm going to say yes.
Okay.
Because live entertainment is defined by a few things.
That's not the
We understand what that is.
I just want to make sure that for the board, when they deliberate, that
hours.
so it's your application hours.
Yeah. Now, here's the challenge. See, those are my COVID hours. Now, June 1st.
Sir, if there's something
So-
different than what's in your
so,
application,
No.
you're going to have to tell us.
Yeah.
And you're going to have to amend the application.
Yeah, and speaking
yes.
in the microphone, because the reason I'm asking is when I read the Charles Village letter, those hours are different than what you have in your application.
When you read the Charles Village hours, the conversation with Sandy.
Sir,
Go
stay over here.
I appreciate you talking to me, but we need you to talk into
Yeah,
the mic.
all right. When we had the meeting with Sandy Sparks, that was back during COVID, and my COVID hours of time when I put it in. What I shared with Sandy is that June 1st, we're gonna go back to our regular hours.
Okay.
And
Whatever
it's just-
change from now versus what's in your application, we need to know what that is.
I'm just gonna open up at 9 o'clock, instead of open up at 11
Well,
o'clock.
no, you can't. We can't do it early.
Yes, you can.
You can, if you know what that's going to be.
So here's the thing. You can go less, but you can't go bigger, right? So, like what you're asking for in this application was that you were going to end at midnight on Fridays and Saturdays, 10 p.m. on Sunday, 11 Monday through Thursday. If you want to stay open until 2 a.m. starting June 1st on Friday and Saturday, that's an expansion of what your original application is asking for.
No, what Sandy took was that when I shared what was the parameter of my business and liquor license, that I have the ability
Okay.
to stay open.
So she's talking about liquor. So as long as what you've put in for your live entertainment is good and that's what you want for the foreseeable future, then that's what the board will do.
12.
Okay.
I don't stay up that late anyway.
So this is what you want, then that's what
And what was that again?
So the hours are from opening times until 11 p.m. Monday through Thursday, midnight Fridays and Saturdays, and 10 p.m. on Sundays.
Which is considerably less. That's right. Which is less. Yes, you're right. And we stick with that. We stick with the
good. I
application.
just want to make sure because it was
You said it's less.
like I said. Then your liquor hours.
Right. The hours in the application are a few hours short of the hours of operation under your liquor license, but we're sticking with the application because it's less. This is our indication of your willingness to compromise.
Okay.
Okay.
Thank you for that clarification.
I just want to make sure. Because you
All
don't
right.
want to go through all this and then all of a sudden there's not a meeting of the minds as to what would the ask was.
All right.
So
Okay.
we understand we will be getting some additional evidence from you.
Yes.
The
Yes,
video.
in the form of the video, and we'll submit that by tomorrow, okay?
I'll submit it by tomorrow.
All right,
You can get it to the board and we will
okay.
have an opportunity to take it into consideration. Is there anything else now that you would like to put on the record? You had a young lady who was going to be speaking, but
She's right here. You know, people came up to testify. I would like for them to be able to put it on the record.
Okay, and
If
again-
they interrupted the day and sacrificed 4 hours, that means we gotta mean something to them, and I appreciate it too.
Okay. You got to raise your hand.
have you been sworn, ma'am?
Yes.
Oh, okay.
You can just state your name.
I'm Belinda Conaway,
Okay.
and I'm here to support Terra Cafe. It's a wonderful venue that they have. Kind of has a tropical feel to it, and the food is wonderful. And we're hoping that they'll be able to expand and be allowed the live entertainment, which will definitely be a benefit. It's a very nice place to go. I've been there not for live entertainment, but I've been there in the garden, and I've hosted an event there, and it's been wonderful. So we're hoping that he'll be able to expand, and I will be able to come to events with the live entertainment, because it's just a nice place to be.
Understood. Thank you, ma'am. Thank you for
Thank
your
you.
presentation. So here's where I think we are. If we're going to leave the record open for additional evidence. Hold on.
Hold on, 1 second.
Part of this goes to the cumulative issue, right? Because we don't want to prolong the record by having everybody come up and saying I
Right.
support,
Right.
which we understand. You have a lot of support here. But at some point, we need to sort of streamline this.
Well, I guess the issue is the noise, right? So if there's
The
anyone.
issue has been the noise, and that was, I think, the bulk of the opposition,
So-
to which was, the direction that you get together, see if you can work out some accommodations, but that's what's on the record,
Right.
on the other side. And so, a number of, I guess, complaints and whatever that history is, which we have obviously a video history of for that earlier hearing, we want to hear the response, to that issue.
Like, do you have any of the people who are here to support you who can speak to the noise level who live nearby or anything like that?
What I can, if I may, I instructed my client to purchase two, what do you call these, sound meters? And to have them permanently installed, and they're set, because the only thing we have to go by is the city noise ordinance. They're set for the levels of decibels that are consistent with the levels, and if any sound exceeds that, these alarms go off and bells ring and lights. But we haven't tested the system yet because we haven't had the opportunity. But as soon as we can, and I don't know, other than individual idiosyncrasies, I don't know how else to do it other than by reference to that, because what's allowed to you is is comfortable to me and so forth. So if there's some other measure or standard that we could use that would be uniform and consistent, we'd be happy to do that. But I don't know any other way to do it. But that's what we're planning to do, to try to regulate the sound, to use these noise meters or sound meters for that purpose.
Okay.
Okay.
State your name, sir.
My name is Dr. C. Anthony Bush.
I'm sorry.
Dr. C. Anthony Bush.
Okay, B-U-S-H?
B-U-S-H.
Very well.
I'm an economist, PhD in economics. I'm also a jazz musician. To the noise issue, as a jazz musician, Terrence does jazz at his restaurant.
I'm sorry. I'm going to ask you to, I know the math will make it a little difficult for us to hear you.
It's hard for me to speak up. I'm just a soft-spoken person. As far as noise is concerned, jazz is acoustic music that is amplified just through microphones. No real big amplifiers or things of that nature. That's his form of entertainment primarily. I live 4 blocks away. In terms of indoor music that he has, you can't hear anything unless you're walking down the street going by the window, But as an economist, I want to speak to the real fundamental issue here. It's the history of black enterprises and their regulation. Okay. Mr. DeShiel already indicated that COVID has had a profound effect on all businesses, and particularly on minority businesses, and particularly on businesses in the hospitality industry. When I moved to Baltimore in 2013 to 412 Lorraine and walked around the neighborhood, his business was there. Okay? I was told by people in that community that this is the Black Wall Street. Pride, a lot of pride in the community. The Black Wall Street.
Let me stop you for a second.
Yes.
We're here on the portion of the case that is rebuttal, right? Or are we?
We don't, there's no opposition here to
No, I
testify, so
understand,
we're still in the.
but this is a continued hearing from a presentation and opposition.
Yep.
And now you're coming back. Hold on, wait a minute. And now you're coming back for basically a reply or rebuttal with additional information as what's happened between then and now, right? Understand? And so I say that because you're giving a long,
No, it's not
to
long.
give certainly a history
I'm
that
giving-
goes well beyond where the record is.
Well, it's the reason why I'm doing this is because I'm a scholar, I'm an expert.
I appreciate that.
And all I'm simply trying to say, from the point of view of African American economic history and what I see going on here, is that we have a small black businessman trying to exist who pays taxes, federal, state taxes, property taxes, pays his employees. He is trying to expand to enhance Baltimore. I don't understand the issue where a community is trying to harm an enterprise that has contributed substantial amounts of income and prosperity to the community.
Okay, well, let me just suggest this briefly. Just as Mr. Dixon has a right to seek approval of the board for any particular variances or any accommodations that the law requires him to come to the board to obtain, anyone also has the right to oppose that for reasons that they can support. Maybe they can, maybe they can't, but they put it on the record as to whether there are things like some kind of detrimental to the community, by evidence of, prior excessive noise, evidence of, could be a number of things. And so that's the process that we're undertaking here.
I understand,
it's a long
but I'm
process.
trying to put a little bit of evidence.
No, please,
I'll sit down.
The evidence we're seeking to have is, in support of Terra Cafe's request for the expansion of their activities with live entertainment. And there are certain rules and regulations that you got to abide by, and there are certain guidelines that the board has to review and be guided by when looking to approve or disapprove any particular application. So part of the process is you come in, you make your presentation, you support it with evidence, you support it with documents, and the other side supports their opposition with the same thing. And sometimes, the board makes a hopefully helpful suggestion. See if you can work things out with the community, because, anytime you can come to a compromise, that's better for all, and that's when we last met, that's where this was. And so now we're coming back to see what the result of that effort to compromise was. We have some question as to what that evidence is, because we haven't seen it all. But these are the things we need to consider in order to make determinations based on the guidelines we have, based on the code.
Well, from what I've heard from,
Okay.
I mean, lots of things can be questioned, sir. Trust me, I understand.
I support him as a economist, scholar, and I don't understand, the lawyer over there, I believe, indicated that he's zoned for entertainment. I just don't understand. Okay, I'll stop.
And that's respectfully, that's not something you have to understand. It's for the board to be sure we understand and at least get the information that's needed in order to render a fair and just decision. And so that's what we're trying to do.
Thank you, Mr. Chair. And as I said earlier, I don't know, what do you have something? Come on. No. Don't, nobody says anything unless you say it to me first.
Does anyone have any testimony that you want to offer regarding noise, not noise?
Do you need a moment to go through them and figure out who's going to testify? Take your time.
Okay. The other witnesses are just people who want to speak in support because they've been here a while. I apologize to all of them who are here. It's, they've seen what's happened. But again, it would be cumulative. You can rest assured that everybody here supports the Terra Cafe.
Sure, we
can.
Can you give me one moment? Do you all support the Terra Cafe?
Absolutely.
Okay.
All right.
Yes. Okay.
All right. And Mr. Chair, I'm going to, if you will excuse me, I have to get to my granddaughter's recital because that's extremely important.
All right, so Mr. Shields, I know you're getting ready to leave. So procedurally, I just want to make sure that everybody is on the record, or on the same page. We will leave the record open. We will receive the additional information. It will be given to the board. The board will have an opportunity to review it. This will come back on the board's general meeting docket. So at this point, testimony will be closed. The record is open to receive this video so that the board can review it and make their own assessment. So it'll go back on the general meeting docket. There will be no more testimony. The board will then deliberate on everything, like everything that it's received. We have all of the letters of support in the file. We have all the letters, we have everything, right? So the board will have the full record and we'll talk about it. Like you just saw them do all the deliberations already for all the other ones. They'll do the same thing for you, but it'll be during a general meeting at 12:30. We'll let you all know when it is. If you can come and listen and watch, right? But you won't be able to participate. And we'll wait for this document. They'll get it. And they'll look at it and we'll reschedule.
That is my,
You can get into it super quick. We'll put it on the June 7th. I want to keep wanting to say June 6th, the June 7th general meeting to deliberate. Okay?
that is my understanding, yes.
Okay.
Thank you.
Awesome. Thank you all.
Thank you.
And Mr. Dixon, you can email that directly to me or to the BMZA at baltimorecity.gov. Yeah, let me give
I want
you.
to make sure I have you.
How are you? You said what? Yeah. Good to see you.
Me too. We almost saying.
The issue of the Roland Park,
Oh, yeah, is that the only one we didn't discuss?
that's one. The question is, do you want to deliberate on that now?
No.
I don't either.
Absolutely not.
I want to review
Yep.
what I've seen and what I've gotten and make that determination.
So we're,
Works for me.
Especially because none of us were here, the four of us, for the beginning of that one. And then the first appeal.
I think we're making our court reporter miserable by talking while there's so much
Oh, sorry.
ambient sound. So why don't we let people clear out and then we can move forward?
Thank you.
So,
Well,
we're still here, like, so thank you guys, we appreciate it, but.
We gotta talk.
They still have one more thing to do.
Can you all?
Well, we
Go
are
out to-
leaving. I mean, we
We
were
just got
just
console
saying how
going on,
upset we was to be here since 12:30.
Oh, yeah.
I probably got a ticket on my car and don't get a chance to speak.
And the people that against us ain't here. That's all I'm saying.
I really don't go to Terra Cafe and eat the fish.
Thank you for the recommendation.
She's like, if nothing else.
But it's a beautiful place, and it's gonna work out. I've been a patron for over 20 years.
I've been in many times.
Yeah, I've been there a bunch of times too.
I'm not prepared to.
Noise is
My daughter's been there a bunch of times.
Your daughter goes?
Yeah.
Roland Avenue.
City college friends.
What we want is for you all to understand,
Ma'am,
We can't,
we can't,
sorry,
we can't hear you.
this
Yes,
isn't
yes.
about,
What-
this is about as a citizen. I'm 61, I pay over $7,000 in taxes here. And the process of disrespect is what we're saying. It was freezing in here. We tried to address it. It's just a total disrespect. And if I were in your shoes, I would try and just be more respectful to people's time because everyone did get here. And I'm a flight attendant. I got in at 1 o'clock this morning. And I've been sitting here. That's how much we love Terra Cafe. So I'm not gonna get into all of that. Thank you for your time. But the building was really freezing and people are getting sick. So that's not fair. And thank you.
Thank you.
All right, so we're still going, still on the record, and we have one
But we-
matter left
yeah,
to
we-
deliberate.
However,
However.
do you think we may want to defer deliberation on that?
Okay,
To the
Because I
general
want to
meeting.
you
review
want to review the documents?
the documents
Okay,
and the bulk of testimony that's there.
it's a lot.
Yeah,
It
it's
was-
a lot.
It was a lot, and
Yeah.
we knew they were, both of them being lawyered up, we knew you were gonna get a lot in writing. We had hoped to get it beforehand, but obviously, we got some.
Yeah.
And then you heard a lot of testimony.
Mm-hmm.
And the good thing is it's on Charm TV, so if you need to,
Right.
Right.
to go back, we can do that too. All right, so
Hopefully.
you want to defer deliberations
Yeah,
on
on that
Roland. Do you think you could do that one, assuming we get the video, from Mr. Dixon in the next couple days? Do you want to do both in the general meeting on the 7th?
Sure.
Yeah.
Which is in 2 weeks?
If we're gonna do that, people need to be on time.
Yeah.
Yeah.
All right, so we'll do it on.
Let me look at my calendar.
And we'll make sure we let Otis, Otis won't deliberate on either one. He can't because he wasn't here.
Let me make sure that's not a date that I'm sliding in at the last minute, because that's how I would want to put it
Because
on.
if not, we can always move it to the following one.
Let me just make sure.
The 21st.
Let's not do that one. There's a chance I actually will be in a jury trial that day.
All right, so we'll put it, then I think it's June, is it the 21st? Okay,
2 weeks later.
so 6/21.
First day. Hold it.
Okay, so right now it looks like I have 3 trials that morning. They should all be done. And the one that I probably will do is like right down, it's in the city, but it starts at 10 a.m. But it should be quick. But I'm literally a block away from the
Okay.
district court, so.
Yeah,
Or
district
this
court.
way. Yeah.
Yeah, I always get turned around when I'm in here.
Yeah, it's that way.
Yeah,
Yeah,
district
so-
court, you
So
should be
you
done.
prefer the 21st?
I would prefer the 21st over the 7th,
All right.
just so that I don't hold us up.
Okay.
For the record, though, July 5th is open, so, but I know that's a long time from now.
All right, I actually just sent an email to, all right, so we are off the record, and the docket is concluded, and we're in complete recess until we come back. Thank
Oh,
you.
wait a minute, do we need to run this?
Well,
Oh,
I
no,
mean,
did
you
it.
kind of
Not
deliberated.
really.
Okay, if we've got
And
it,
then
great.
the other ones were by consent.
The other ones were by
Okay,
consent.
great.
So no reason to run the docket. I did just send an email while we were